Morning, everybody. I always love emerging through that curtain. It's kind of For those of you who don't know me, my name is Jim Anaya. I'm the Dean of the University of Colorado Law School. It's my pleasure to welcome you to this conference, which is organized by the law school's Silicon Flatirons Center. As many of you know, Silicon Flatirons is a hub of innovation at the intersection of law, policy, and technology. In addition to its policy work, the center hosts dozens of conferences, workshops, debates, and fireside chats throughout the year, bringing many of the best and brightest thinkers from around the world to the law school and our community. As Dean, I'm extremely proud of what the center does to contribute to the life of the law school and in particular to provide opportunities for our students. I'd like to recognize the newly appointed interim Executive Director of the Silicon Flatirons Center, Harry Surden. Harry will be serving until a new Executive Director is chosen to fill the position that was left vacant by the departure of the longtime Executive Director, Phil Weiser, to become the state's Attorney General. And of course, congratulations to Phil Weiser for that accomplishment. I'd also like to acknowledge and give a special welcome to the newly admitted students to the Colorado Law School, who I understand are here, or some are here, I believe. They've come to Boulder to get a firsthand, close-up look at what happens here at the law school and in our community. Today's event is the annual Content Conference, now in its 5th year. This conference is particularly focused on bringing diverse viewpoints together to identify common problems and solutions. This year, we're especially proud to host preeminent experts from across the country who will talk about the impact that intellectual property laws and gender have on one another. Welcome to each of the presenters. The title of today's conference could not be more compelling. It's a Barbie. World, intellectual property rights, rights of publicity, and the gender wars. I didn't come up with that title, but it's a very creative minds, or a mind did. And I'd like to say that from day one, 2 of our students, Chloe Blaskowitz and Colleen McCroskey, have been involved in the planning and execution of this conference along with our outstanding staff who are also in the room. Please join me in a round of applause for thanking them for their work. Now, it's now my pleasure to introduce Professor Cristelia Garcia, who is the mastermind behind today's event. Professor Garcia will introduce our keynote presenters, and then along with Chloe and Colleen, will moderate the roundtable discussion that follows. A graduate of Columbia University and Yale Law School, Professor Garcia teaches and writes in the areas of copyright and trademark law. Prior to joining Colorado Law, Professor Garcia practiced law in the music industry in Los Angeles, first at Quinn Emanuel as outside counsel to Napster, then as director of business development in charge of content licensing at MySpace Music, and most recently in digital strategy as director at Universal Music Group. Colorado Law is very fortunate to have Cristelia as part of our faculty. Please join me in welcoming to the podium Professor Cristelia Garcia.
Thank you so much, Jim, for that warm welcome, and good morning, everyone. Thank you for being here. We are particularly excited about today's topic, not least of all because we're trying something new, so I look forward to if those of you who will get the little survey in your email, let us know what you think. We're doing this roundtable style. I'm especially personally excited to welcome as our keynote presenters today 2 scholars, Orly LaBelle and Jennifer Rothman, who are such inspirations to folks like me who are getting started in the world of academia and in intellectual property. They're going to be discussing 2 truly amazing and blockbuster books today to get us started. And then we will be joined by a host of experts in this area to talk about something that I think is prevalent but not often acknowledged as such, and that will touch on a lot of issues at the intersections of intellectual property and gender, right? Things that, ways in which gender can impact decisions, can impact culture, whether or not they're directly acknowledged. And we see these kinds of issues in intellectual property often where we say, the law is causing this to happen. A recent example, I was reading a draft, perhaps the law of derivative works is causing more franchise films where we might otherwise have standalone films, right? So there's lots of these sort of tangential and potentially unintended effects of intellectual property law. And today we're going to look at those, but in the particular lens of gender. So I think it will be a lot of fun. Without further ado, I'd like to introduce our first presenter, Orly LaBelle, who is a professor at the University of San Diego Law School, also a founder there of their program on intellectual property and markets. The book that she's going to be focusing on today, You Don't Own Me, the story of the Mattel versus MGA litigation, which we've talked about this very briefly. I actually spent several long years of my life doing when I was at Quinn, is a well-known litigation. So it'll be really interesting to get the story. And if you haven't read the full account, I highly recommend you grab the book. That will be available afterwards for our lunch and our book signing if you don't already have your own copy. And so she'll be discussing that. Then we'll have a switch over. I'll give a brief introduction to Jennifer Rothman, and then we'll hope to have you guys join us for the roundtable and questions. I will be taking a brief couple of questions in between Orly and Jennifer's presentations, so that if you have questions specific to some of the topics that each one will be raising, we can ask them at that time. All right, without further ado, welcome to Orly LaBelle.
Good morning. So if I had to dream of an event when I was writing this book that would be related to the publication, this would exactly be my dream, my wish list, all the speakers and the program. So I'm incredibly grateful for Cristela and all the organizers and University of Colorado. And yeah, I feel so lucky. I think I'm gonna buy a lottery ticket today. So it really is a great honor. I wrote You Don't Own Me to tell a specific story, and it's a full story. It was the first time I told kind of a Michael Lewis style story. We have the same publisher actually, Norton, and I thought it was a very cinematic, character-driven litigation that had so many ups and downs and twists and turns and very, very colorful personalities. So it was also the first time that I did very deep interviews with all the major players, the CEOs and the jurors and the judges and the attorneys on both sides. So the story, if you don't know about it a little bit, is a shy designer named Carter Bryant who has been working at Mattel for several years. He is frustrated with just his job of designing a different dress every few months for Barbie, changing up a little bit of her color and makeup. And he really sees the world around him changing, sees Barbie as constantly, being perfect in a kind of enraging way. He feels a little bit of an outsider. He's gay, and he has these dreams of having a more empowered, different, more realistic, perhaps, and perhaps more feminist idea of a doll that will challenge this huge, dominant actor that's been dominating the toy market for several decades, for over 5 decades since she came out. And so the question of when he comes up with this idea of brats is very much part of the driving force of the litigation, and that's really interesting, of like that moment of eureka and where does inspiration come from. But he comes up with some sketches of a bratty doll, a multi-ethnic doll, perhaps over-sexualized, although she gets sexualized at some point too, and unrealistically perfect and a huge breast doll like Barbie, and sells his idea to a small competitor. And that's just the start of a decade-long battle. So when I wanted to tell this story, what I wanted to first of all say is that in some ways this is a very specific story to the toy and entertainment and content industry, but it's also a universal story. And I felt like we had a lot of these stories when we look at the tech industry and Silicon Valley, and we all kind of know that we care about Uber versus Waymo, and Oracle and Google, and Apple and Samsung, all these big IP litigations. But I think that it's a neglected field of how that same kind of dynamic of dominant actors and then smaller competitors and new entry and different kinds of products get played out using IP and the sledgehammer of the law. So I wanted to tell this story and say that this is actually at least as important to us to understand what happens in these industries. And when I think back of what inspired me to tell this story and not like a more traditional tech story, I can actually trace some of me being a critic of the toy industry to growing up. So in the book, I revealed that when I was 6 or 7 years old, my mother, who's a social psychologist, would pose me in her own research as in these videos where I was playing with boy toys versus with girl toys, and she ran these experiments all over the world. And it was very consistent. When the subjects of her study saw a girl playing with Barbie or tiaras, I was considered less smart, less of a leader, less of likely to succeed. And so these choices really matter. They matter from childhood, they matter for our decisions as parents, they matter for our culture. And they matter to me. I'm a mother of 3 girls, and our wonderful former nanny is here, Alex, who can attest that they are wonderful girls, and they don't play with Barbie. But the tracing back the research goes more immediately to my bigger field of research, which is at the intersections of intellectual property, employment law, antitrust law, and contract law. And for a long time now, I've been looking at those intersections and arguing that beneath the radar, the bargain that we think that we drew and struck in intellectual property is not the bargain that we have, that much more knowledge is enclosed through contract. And that was part of the argument that I developed in my previous book, Talent Wants to Be Free, and a lot of research that you can find online. And one of the exciting things is that there's a lot of empirical research on how, for example, non-competes, there are very different jurisdictions in enforcing them. So in California, we allow that kind of movement of a person like Carter Bryant to go directly from one competitor to another. And also, it's not just Silicon Valley, it's also pharma, but it's also, as I said, Hollywood, and there are cases like that too. And the empirical research is so strong these days. So I was invited to the UN to be part of a report that compares different countries and how much they enforce or allow mobility of talent and brains and knowledge and flow and spillovers, positive spillovers of ideas. And consistently, those countries that do allow that win out and develop more quickly. In 2016, I was very fortunate and grateful that I was invited to the White House to speak about Talent Wants to Be Free and my research on mobility and talent flows. And it was a moment where I had been arguing when the book came out that nobody's thinking about this. We're all thinking about exactly the lines that we draw in patents, right? Are we over-patenting or under-patenting? But nobody was really paying attention to all these contractual arrangements. But suddenly, even the president and his policy team and the Treasury Department and the FTC now and the Antitrust Division and the Labor Department and different state attorney generals are all actually very interested in understanding these differences and what we think of as the California model of non-enforcing some of these contracts, the straightforward non-competes, as really beneficial to innovation. But, and here's this big but that comes to why I wrote the next book, You Don't Own Me, it's not just non-competes, it's such a dense network of contracts and doctrinal arrangements that mean that people are not free. Talent is not free, even when we strike down the traditional non-compete. Because Carter Bryant was in Southern California, but he had these really draconian assignment clauses that basically said that any idea that he has, so remember, ideas are usually not patentable or copyrightable, it's in our statutes, but when it comes to a contract, suddenly the judges, the courts forget that wisdom. And he also had a very draconian assignment clause and NDA in terms of the longevity or how long it lasts. So post-employment, he kind of becomes untouchable when he's signing away so much of his human capital and his experience and his skills. So in the new paper, I'm writing about all of these different arrangements that create this thicket in the contracts in controlling knowledge. And I wanted to just show you an image. This is last week in an antitrust law conference where the other step of the new conference, or this new paper, and this was really inspired, thanks to Crystalia, by this conference here when we're thinking very specifically about gender. I'm also pulling together what I had hypothesized but didn't really do in a rigorous way, that all of these arrangements have disproportionate harm on gender and also on other vulnerable workers, including minorities, and they have different effects on age, correlating with age. And so in that conference, the speakers were imbalanced in the other direction. I was the only female law professor at that conference, and it was almost like history repeats. I like the slide showing that we haven't come far enough since Marilyn Monroe did her movie. But the evidence is there, so it's really emerging that if you think about non-competes and assignment agreements and NDAs, they all have disproportionate effects on women. What I'm arguing is that the gender gap is actually compounding when industries are concentrated, where there's one or two or a few dominant actors that are the people that hire you, and you don't have a lot of choices. So the people stay in hostile work environments, they stay in places where they are unethically treated, where companies don't value diversity. That's one effect. Another effect is that the job hopping is actually exactly the engine of eradicating the gender wage gap. Because if people are fought over, their talent is fought over, their experience is fought over by a tournament between different employers, that is exactly the way that the market is perfected in that sense of eradicating biases in pay. And Talent Wants to Be Free, my previous book, was just cited by an en banc decision of the Ninth Circuit Court of Appeals in an equal pay, Federal Equal Pay Act case, and it says exactly that hopping is what is the engine of correcting all of these biases. There's also a lot of behavioral problems with having that sledgehammer over you, whether it's patent litigation or copyright litigation or non-compete or NDA litigation, that we actually know from the behavioral studies that women on average have a negotiation deficit. They don't ask for more. They don't negotiate out of draconian contracts as frequently. When they try to negotiate, they face a penalty versus when men ask for the same kinds of rights. And they're also, on average, more risk averse and have less backing to take those kinds of risks of, because a lot of what we see, and this is a very important point in You Don't Own Me, is that companies that are dominant, they can use the law even when they have a losing case. And Quinn Emanuel in my book doesn't come out very well. As somebody says about them, they're bullies representing, or they are the, Mattel is the bullies that are represented by bullies. And they have a lot of losing cases, but they still go for those losing cases. And that's very important to think about too when we are thinking about what IP does. And so I mentioned already that we have in IP these ideas of lines between intangible property and that is too far on the intangibility spectrum that should not be propertized. So ideas, too abstract, things that have not been reduced to practice. And all of that wisdom in the Mattel case, because Judge Kaczynski, who's another story in itself, and he's a character in the book, and when the New Yorker reviewed my book, they led with the scene where I'm sitting down with Kaczynski and asking him about having seen a lot of these Barbie cases, and I say, I was raised by a mother who said that Barbie sends the wrong message to girls, and he looks at me puzzled, and he says, the only thing wrong with her is that when I lift up her skirt, I don't see anything. So, and I don't think he thought I would put it in the book, but it is in the book. And that all came out 2 months before he resigned. He on copyright, he gets the law right in so many ways. He understands that we have to have a big, active public domain. And he says Stephanie Meyer can't, copyright the idea of sexy vampires. Degas can't get a property right in just drawing dancers. It's really just the specific expression that gets the copyright. But then when he looks at the contract itself, he forgets that. He has just like a completely different worldview, and he says, oh yeah, maybe you can create property in very intangible, the most intangible kinds of ideas of like a bratty doll, just by putting that language in a contract, in a pre-invention assignment contract. And I'm very critical of that development, and it's very pervasive in every industry that you look at. So I mentioned, these lines, we have to think about these lines of intangibility and the lines of uncertainty in every pillar of our intellectual property and antitrust and contract world. So I want to argue that, again, uncertainty has a patterned effect. It creates dominance, it creates concentrated markets, and it has a disproportionate harm on those that are traditionally excluded from culture creation, for content creation, from from markets, from innovative markets. And so you see Mattel going after artists and singers and music producers and photographers. And again, they have losing cases and they consistently lose. But the uncertainty there of what is fair use is really what has that chilling effect that's very harmful. And of course, one thing is that history repeats, and if you look at every creation, in the book I reveal how Barbie herself has a history, an unknown history to most people. She is really lifted from her doppelganger, a German post-war doll, and just straight out copied. And at the inception, there's a little bit of an IP dispute, but it goes away, and that becomes the forgotten history. So really, every intellectual property case, when you look back in history, you see some of these repetitive historical accounts. So I'll just end by saying, well, I hope you read the book. I had so much fun writing it. The Financial Times said that usually intellectual property is a relatively dry topic, which I don't agree with. But they say in the hands of Lobel, it becomes something of a page turner, and it was very cinematic to write it. And I think that I think there is something probably just on the gender side, gendered about doing the deeper ethnographic studies and qualitative talking about the culture creators, rather than just counting numbers and not seeing what's behind those numbers. So I think there's something there, Finally, there's an intellectual property story everywhere, and there's even an intellectual story with the irony of writing a book about fair use, and then your publisher getting really nervous about their first cover design that has only Barbie on the cover, and she's shaded, and the general, again, I'm like, read the book, I can do this, I'm not competing with Barbie, I'm not selling dolls, I'm doing critical commentary and as a professor, and they still were so worried, and their general counsel said, let's chill this, let's not be on the lines, but way, farther from what really the lines that we draw in intellectual property are, and there was a second cover. So thank you.
You can come back up after she's done. Thank you so much to Orly. I was thinking the Financial Times has a lot of nerve talking about dry topics, but in any case, I want to welcome now our next keynote presenter. Jennifer Rothman is joining us today. She's a professor at the Loyola Law School in Los Angeles. She is also an affiliated fellow at the Yale Information Society Project at the Yale Law School and an elected member of the American Law Institute. The project that she's going to be presenting today, her latest book, The Right of Publicity, Privacy Reimagined for a Public World, focuses on her specialty. She is the leading expert on rights of publicity, and in fact, for those who are curious, she also has the definitive website on this, Rothman's Roadmap to the Right of Publicity. It's rightofpublicityroadmap.com. So if you ever have any questions or are seeing little news clips here and there about, whether or not what someone can do or can't do in terms of using or prohibiting others from using their name and likeness, that's a really great place to start. So without further ado, I will turn it over to Jennifer. Thank you.
Thank you. Thank you to Christella for inviting me to talk about my book and be part of this conference, and to the University of Colorado and Silicon Flatirons for sponsoring the event. I want to disclose upfront that I do not have any pictures of Ken in bondage, though I love that photo. But what I'm going to be talking about is a law that potentially could place all of us in a form of bondage by allowing others to own our names, our likenesses, our voices, and other indicia of our identity. So I'm going to be talking today about my book, The Right of Publicity, Privacy Reimagined for a Public World. And then I'll talk about some of the things to spin out about that I think raise issues of gender, although that's not the focus of the book. But if you're interested in some of the issues I discuss, I hope you will take a look at the book. In the book, I debunk the conventional story of the right of publicity's development. And by doing so, I provide a path to hopefully resolving many of the problems that today's right of publicity presents, from the danger of losing ownership of your own identity to the right of publicity's clashes with copyright law and the threat of shutting down speech, particularly speech about public figures. And I'll mention that the cover to my book also has some IP issues. This was not what I proposed, but they wanted anonymity and nothing recognizable on the cover. And so I like it, but it's very different than what I proposed. So I'm going to start today by setting forth part of the central argument of my book as a foundation for discussing some of these equitable control issues that raise issues of gender and also others who have less control in the bargaining process. And at the beginning, though, I want to set up a framework. Many in this room already know what the right of publicity is, although I'll mention that if you haven't read my book, probably most of the things you think about the right of publicity you think you know are wrong. So hopefully I can at least start correcting that now. And if you don't know about the right of publicity, let me give you a small primer, which is that it's a state law that provides a right to each of us to stop others from using our identities, particularly our names and likenesses and sometimes voice, usually for a defendant's advantage. Sometimes it's thought of as a property right in one's own personality. It's not an absolute right, though. You can't stop everything people say about you or ways in which they use your image or your voice, because it's limited by countervailing interests, particularly the First Amendment. The definition I give here of the right of publicity is quite broad, in part because it varies widely from state to state. So in contrast to the right of privacy, which is pretty consistent across the 40 states that have explicitly recognized it in their tort law, the right of publicity varies widely from state to state in what's covered dramatically in who's covered by it, who can bring claims, how it can be infringed, and what sorts of uses are exempted. And because of this variability, as Stella mentioned, I did create a website so you can click on a state and find out the law in that state, and sometimes as time permits, I provide commentary on major cases or issues in right of publicity law. I contend in the book that the right of publicity lost its way when it shifted from something rooted in the individual, whether understood as a property right or not, into an intellectual property or quasi-IP right that could be taken away or transferred to others. This is the shift that has jeopardized our control over our own identities, which is a central concern of the book, but it also has set up a world in which the right of publicity has dangerously expanded in ways that limit and interfere with creative expression and even with news reporting. At the same time, the right of publicity's unmooring from the right of privacy has led to an identity crisis in privacy law, narrowing privacy laws for the worse, and making it so that privacy laws are often limited to claims by private figures and only when information is deemed secret or undisclosed. So the right of publicity has narrowed privacy law while becoming more expansive itself and doing too much in the wrong places and too little in the places where it should be doing more work. So I propose that in order to allow publicity laws to do their good work, the work of protecting privacy in our digital age, without shutting down speech about important public figures and public matters or unduly limiting creative expression, we need to reclaim some of the core insights of privacy law and privacy's harmony rather than its divergence with publicity law. To the extent that you've heard much about the right of publicity, you probably think that it was created in 1953 in a Second Circuit case, Halen Labs v. Topps Chewing Gum. These are actual baseball cards from the litigation involving Wes Westrom, if you're a baseball aficionado. I hold these cards in my collection, but I also went through all of the files for the case where they're decaying cards and decaying, crumbling bubble gum as well. So the well-accepted story of Halen is that Halen coined and created a right of publicity. Nothing about that is true. It neither coined the term, didn't create the right. But it's often said that Halen provided a right to public figures, these baseball players, to control uses of their names and identities. And that because, and the argument goes, that privacy law didn't protect them because they voluntarily injected themselves into the limelight and therefore suffered no personal injury from the use of their identities and therefore could not bring a privacy-based claim. Instead, their injury was an economic one that needed a new claim to provide them with a remedy. So the story goes that the Second Circuit needed to create this right to protect the baseball players whose names and likenesses were used on trading cards by two competing companies. So no part of the story is true, except that there were trading cards and there were baseball players on it and there were two competing companies. But the litigation never involved the baseball players. They were not parties to it. And the law long protected the baseball players' rights to control uses of their names and likenesses, even in a professional capacity. So in fact, the two leading trading card companies, here it was actually Bowman Gum, the predecessor to Halen and Topps, had each gotten contractual permission from the players to use their names and likenesses and statistics and paid them for the right to do so. So this was actually not a case about protecting baseball players, but was a case about taking control away from the baseball players who had given permission to both companies and transferring it to the companies. In reality, the case was primarily a contract case, and despite the flowery language about the right of publicity and creating something new, the federal court claiming to create something new under New York law, was never recognized as creating anything new. And on remand, there was simply an admonishment for the trial court to read all these contracts between the players and the companies to see whose rights prevailed. The right of publicity, both as a term and as a concept, dated back to the 1800s. And here are some examples of the right to publicity that date back to the 1800s and the early 1900s, long before Halen. But this dicta in Halen about potentially creating a right of publicity, even though it was not true, carried weight with others and started sort of created an opportunity for others to expand the law in a way that would be helpful not to individuals like the baseball players, but perhaps to companies, something that we'll return to in a moment. So just to sort of further this reality check as to privacy and publicity, it's often said that they're opposite sides of the coin, that the right of privacy is about protecting those who are secluded and secret and private figures, and the right of publicity is about pecuniary advantage. But this turns out not to be true. The right of privacy long protected the very same interests that we say are protected by the right of publicity. So the original right of publicity was the right of privacy, and it protected all the same sorts of things. So the typical right of privacy cases, and the one that led to the adoption of the right of privacy in the United States, were these ads, uses of people's photographs in advertisements. The two images up on the screen may be familiar to you if you studied early right of publicity cases. The left one is from Roberson v. Rochester Folding Box Company. It was an instance in which a young woman sat for a photograph, and then her photograph was used on a flower advertisement without her permission. So she voluntarily sat for the photograph, then the photographer licensed it for use on the advertisement. She sued, she objected. The case went to the highest court in New York, which decided, the New York Court of Appeals, which said, we're not going to adopt a right of privacy here. We're very sympathetic, but that's something for the legislature to do. Outrage followed in the wake of the rejection of her claim. In less than a year, in 1903, New York passed one of the first right of privacy statutes in the country to expressly prevent the unauthorized use of people's names and likenesses in advertising, or more broadly for trade purposes, which remains New York's right of publicity law today. The image on the right also is an instance in which someone voluntarily sat for a photograph, Paolo Pavicic, who's on the left in that image, and then the photographer gave the photograph for use in an insurance, a life insurance ad. He sued, also under claiming a violation of his right of privacy as well as defamation, and the Georgia Supreme Court became the first court to recognize that common law, the first state high court to recognize that common law right of privacy, and recognized his claim. With our mistaken historical lens about the divergence of privacy and publicity law, we tend to think of these cases as emblematic of claims by private figures, but they were part of a much larger conversation at the time about controlling publicity about oneself, a conversation that included and even featured public figures and celebrities of the time. So privacy did publicity's work. So public figures had claims at the time, from Marion Minola to Nancy Flake. On the right there is Fred Astaire a little bit later. Third from the left is Charles Eliot, the president of Harvard. Public figures routinely brought claims and prevailed under privacy law. a particular relevance for this conference, men and women brought claims, privacy-based claims, and succeeded, whether they were public or private in nature. In fact, we see a lot of claims by women who are performers at the time. And one of the places where we see a divergence a little bit is in the way in which these claims were made. So the women who are bringing professional, reputational-based claims were performers, because it was one of the few job opportunities available to women at the time, whereas men who were performers also brought claims, including professional, reputation, and economic harms, but also businessmen, doctors, scientists also brought claims, and we don't see women in those fields at the time, or not very many of them bringing claims. And then we also see both private figures who are men and women bringing claims at the time. So there were claims. These claims were not limited to dignitary and emotional harms under privacy law. There were also property-based harms for lost endorsement fees, for injuries to professional reputation, business prospects, et cetera, including by women plaintiffs. This is an example in the middle of Gladys Loftus, who brought a suit. There were a number of suits, including by women, who brought claims that were not in any way related to emotional or dignitary harms. Sometimes they sued for the circulation of publicity stills that they themselves promoted and authorized to circulate, but they just hadn't authorized this particular use of their image. Now, I will note that there was instances in which some of the claims turned on a sexualization of women that they objected to. Justice Taizé, we see actors and models particularly suing. There's been a slew, if you follow these things, suits over models objecting to the use of their unauthorized images to advertise strip clubs. And early on, we saw, going back one slide, Mary Manola on the left, objecting to being photographed in tights, even though the image was taken while she was performing on the stage in a theater. So everyone could see that she was wearing tights. She just didn't want the image of tights being further circulated. And we also see a number of objections by other women to their uses, even though they're performers, of their images being improperly used in connection with burlesque theater, which had sort of the same sort of strip club, I think, objections that today's people do, today's women do. And the recoveries included substantial economic recoveries, despite frequent claims to the contrary. All of this was true under privacy law. So what was privacy law missing? Well, what it was missing was transferability. And this dicta in Halen, even though that wasn't what the Halen case was at all about, sent a sort of wonderful opportunity up into the air for Hollywood and Broadway, and also for heirs of dead celebrities. So I have Mel Nimmer up on the screen here because in 1954 he wrote the most influential article on the right of publicity. He claimed, incorrectly, that Halen created something new, that privacy law did not provide rights to protect their images to the baseball players, which was not true, and he glossed over many claims the corporations could have used at the time to enforce their rights against double booking by the baseball players and against the competing company under existing tort law. But he had good reasons for wanting to read Halen a certain way. At the time, he was an attorney for Paramount Pictures. In the 1940s, those of you who follow Hollywood probably already know this, but if you don't, we used to have a star system in which the actors were beholden to a particular studio. They signed long-term contracts that they couldn't get out of that limited who they could work for, what roles they could take. They had been invalidated in 1944 in a lawsuit involving Olivia de Havilland by the California courts. These contracts were all under California law. And so the studios were searching for a new way to control their stable of actors. What better than being able to own, literally own, their names and likenesses and voices? And so Nimmer advocated for such a right in his seminal article on the right of publicity. And there's several telling examples of this, but one I'll highlight here from the article. He advocates for a right of publicity so that studios would be able to stop one of their actresses from booking a bathing suit advertisement. Right, a bathing suit advertisement. He said, first of all, the studio should get to decide if she gets to be in a bathing suit advertisement at all. Is that part of the studio's vision for her? And then certainly we wouldn't want her to be able to book 2 bathing suit advertisements because the studio should get all the money from those advertisements anyway. And so we should get to make an exclusive deal with one advertiser for studios, for bathing suits. So here, this notably suggests that the right of publicity could actually stop the actors from doing things, right? It wasn't just a right to get the value, it was the right to actually stop the actors from doing things. Another impetus for this turn towards transferability that privacy law didn't allow was inheritability. And the heirs of celebrities were particularly keen on transferability so they continue to profit from others. On the right is Elvis, who died in 1977. While he was alive, his manager got 80% of his earnings. And within a couple days of him dying, his manager, not his family, his manager raced to the courthouse to try to get his rights transferred to him in death, so he could continue to profit after Elvis in death. So these arguments by heirs, by Mel Nimmer and other Hollywood and studio attorneys sort of percolated in the air for decades after Halen without really going anywhere until the Supreme Court's decision in Zucchini v. Scripps Howard Broadcasting in 1977, which really severed the right of publicity from privacy and turned it into this transferable intellectual property right. I talk a lot more about this in the book, but this was a case involving the news showing a 15-second broadcast of a human cannonball act. And the Supreme Court, in the only right of publicity case it's ever heard, rejected a First Amendment defense in that instance and highlighted the differences between the right of publicity and right of privacy in that case, even though it had been brought under Ohio's privacy law, which rather than any right of publicity claim. Anyway, we can, if you want to hear more about that sort of bizarre turn of events, you can read more in the book. But I want to highlight just for today's talk that this shift to treating it as intellectual property led to it greatly expanding and also limiting the effectiveness of First Amendment defenses and copyright preemption defenses against right of publicity claims. And it also set up a world in which the right of publicity could be transferable. And this is one of the first things when I switched to sort of talking more about some of the issues for today, is that there are major problems with having a transferable right of publicity, and that are highlighted by power differentials and raise some significant concerns, I think, when we talk about gender. So if it's transferable, that means that it's transferable to spouses when you get divorced. It's transferable in bankruptcy and to creditors. It's also transferable by parents of their children, right? So a parent could transfer their child's right of publicity, the rights to their name, likeness, and voice. The children cannot get it back if it's truly transferable, as the law claims in many states. But it's also transferable in voluntary contracts where we might see problems with bargaining power differential. I give the example in the book of Ariana Grande. You might imagine that as she's starting out in her career, she meets with a manager, happy to represent you, Ariana, just sign this contract, and then of course it would transfer for representation to get her first recording deal or acting job, her right of publicity to this manager in perpetuity and in any context. Well, this again is not just about rights to profit from Ariana Grande. This controls what she can do. If you are an Ariana Grande fan, you might know that she is vegan. So her manager could force her image, not her literally, but her image to appear in a commercial for Oscar Mayer bologna. This would be anathema to her. Her manager, as the owner of her publicity rights, could also stop her from appearing in an ad for Nasoya tofu, but it could also stop her from appearing in events for PETA, People for the Ethical Treatment of Animals, something that might be a cause that she's very passionate about, or from appearing in promotional campaigns for that organization. And we might see a differential impact both for young people starting out, but particularly for women who may be less powerful in the bargaining process. We also see this transferability and just the existence of the right of publicity leading to an objectification of people, which may have a disparate impact on women, but not necessarily. I have the Einstein doll here. My favorite example is in the middle of Betty Page, which is now owned. Betty Page, who's dead, if you don't know, the famous pinup artist, is owned by a company, CMG, and they use her name and likeness for their sex toy line. That they promote using her image. I don't know if that's what she had in mind when she transferred it to them. At the same time, I want to just highlight there are also a ton of speech issues here. So it's not just about ownership and control being taken away from people, it's also limiting what the public can say, including comments about people that we might want to talk about or sophisticated conversations about gender itself. Here are some examples of litigation in which the right of publicity was asserted to try to stop uses of public figures. I also want to highlight, in sort of setting up our discussion later, some valuation differences. So we also see vastly disparate recoveries in right of publicity cases, in part because the women are less valuable in the marketplace, in part for endorsement reasons and others. So here are some examples of differential recoveries, the top 4 in right of publicity cases. Vanna White in 1988 recovered $400,000 for appearing in or she didn't appear, but a robot with a wig. I actually think it's a terrible decision and she shouldn't have gotten anything. But if she recovered, right, because she was used, she only got $400,000, equivalent of about $870,000 today. Bette Midler probably has a better case. They did a sound-alike recording of a song she made famous in an advertisement for Ford Motor Company. She also recovered only $400,000 in '89. Compare this to Michael Jordan's recovery for a congratulatory one-page advertisement by a supermarket celebrating his induction into the Basketball Hall of Fame, which was not necessarily exploitative, and he recovered $9 million for that. Tony Twist, who's an NHL player who was honored by being known, having a character named after in the comic book Spawn, the Tony Twistelli mobster character, recovered $15 million for use in a comic book. And then I just at the end highlight another differential recovery in the context of privacy-based claims. Hulk Hogan sued over a clip from a sex tape that was released on Gawker, put Gawker out of business. He got $115 million. Erin Andrews did recover, and she got a big recovery of $55 million, but it's half as much, for someone putting a hole in her hotel room and filming her naked while she was there and then circulating those images on the internet. So we see some differential recoveries here, and part of it is because of who is treated as valuable. In terms of dead celebrities, there are only 2 women in the top 15, not top 10. Marilyn Monroe at number 8, Betty Page at number 13, and tracks endorsement deals for the living. No female athletes are in the top 10 endorsement deals. Female actors fare better than male actors, actually, primarily because of cosmetics endorsement deals. And also the differential and pay for actors is emblematic also of the differential value. If we focus on economic harms and economic recoveries, we're going to see differential recoveries between men and women. The purple here is all men and their earnings for salary, and the orange is women. You go quite a ways down before you get to the women. So I think this sets up some opportunities for trying to fix these things by fixing some things in the right of publicity. One is limiting the transferability of the right, perhaps prohibiting its transferability, and eliminating the commercially valuable distinction that's in some of the laws that prevents people who lack commercially valuable personalities from bringing claims. The importance of recognizing non-economic harms, adding statutory damages to level the playing field. And some of these changes will allow us to use right of publicity laws to address, I think, some current concerns, revenge porn and deep fakes, which also are differentially affecting women in particular, and also shifting so that we're not as focused on economic harms in the First Amendment analysis itself, because the law currently is backwards in the sense that we have the least First Amendment protection when you're talking about public figures who are the ones we most need to speak about and refer to specifically, while private figures who are interchangeable seem to have very little speech protections in the context of trying to bring publicity or privacy claims. So with that said, I hope this sort of leads to good fodder for our discussion in a little bit, and I welcome any questions or comments.
In the few minutes we have here before we take our break and get into our roundtable, I realized that despite having announced we were going to take questions after each presentation, I was in such so eager to introduce Jennifer that we didn't. So we will now take a few minutes. If anyone has questions specific to either or both of the presentations, I'll invite Jennifer and Orly to come on up and take whatever seats they'd like. And we have a mic, I understand. So, here they are. Yeah, we have a mic. So if anyone has any questions, we will start here with Alex, and then I will run a mic around.
So thinking about, those were fantastic presentations, first of all, thank you. Thinking about corporatization and valuation around rights of publicity,
I'll start over. Thinking about propertization and valuation around rights of publicity and gender issues and objectification at the same time. Orly, I had a question for you about a choice you made in writing the book, which was to address, to reference Barbie using human pronouns. So talk about her as she and her. There was a lot of kind of anthropomorphizing and treating her as the main character in this story and as kind of a human character. That was really fascinating and intriguing to me. So will you say a little bit about that?
Sure. I don't think I have a mic, but yeah, that's a great question. So when I started writing the book, when I started talking to the characters in the book, there was a moment where I realized that everybody in that industry has this idea that Barbie is real in some way. So it was, and it's really striking. It's so all of the executives on both companies. The CEOs of Mattel are these professional CEOs, white men who just jump seamlessly from industry to industry. And Isaac Larian, who's the CEO and founder of this startup, MGA, that develops brats, he's an immigrant Iranian. He likes to say about Bob Eckert, he came from cheese. He doesn't know anything about toys, and he's not passionate about these dolls and everything. And but they all there's kind of this vision or image that I saw of these grown men holding their dolls and really believing that they're protecting her honor, protecting her dignity, protecting what she represents. Barbie has a website. She has an Instagram account. She, has this whole life story that's very elaborate. She gets divorced. She gets back with Ken. It's that genius of franchising. And I actually have this whole chapter in the book about the marketing, the first kind of way in which Mattel convinced mothers to actually buy this overly sexualized, unrealistic doll for their daughters. And they hired a marketing guru who is a social psychologist. And it's really kind of the original Mad Men idea of like playing into all of your insecurities. And it was the same guy, it turned out, who also helped market cigars and cars and just use really this idea of your personality to make a product much more than a product. So I think I was kind of responding to that idea that everybody had in their mind of we are here to elaborate this in some ways very real person, friend, role model that's named Barbie. And they do, the two CEOs really do mimic. So Barbie is also very white. There's a lot in the book about not only how she stayed very unrealistic in her body image, but also in her ethnicity for a long time. Maybe one step forward, two steps back when Mattel was trying to grapple with making her more multi-ethnic. And Isaac Larian, who has played up his kind of underdog being an Iranian, a Jewish Iranian. There's also an interesting story in the book about how race played out in the courtroom and some racial biases against him as a defendant in the first trial. So he holds the doll and he's like, the first doll, one of the first dolls is named after his daughter, and she's multi-ethnic. She looks like his daughter in a lot of ways, and his daughter now works at Bratz or at MGA and dresses like it's almost like you don't know who looks like who are the humans imitating the doll or the doll imitating the humans. But there's a lot of play in that, and I think, and it's nice that you picked that up.
What happened to the right of publicity between the Nancy Sinatra case and the Tom Waits and the Bette Midler cases? You know the cases I'm talking about? Okay, the Nancy Sinatra case, she sued, I think it was Ford or some auto manufacturer over an advertisement that had a sound-alike, lost, no right. Years later, Tom Waits and Bette Midler come along, sue over sound-alikes, they win. What was the change in law?
Well, that has to do more with the doctrine of copyright preemption, and I have a whole chapter in the book about that. So I'm not sure that anything happened really in the law, except that we have a much more expansive view of what the scope of the right of publicity is. So it's no longer, particularly as California law, remember that the right of publicity varies widely from state to state. So California law, as interpreted by the federal courts, which if you recall Erie, they can't actually decide state law, but they have. So particularly in the Vanna White case, which I mentioned the recovery of, there was a robot in a blonde wig in front of a Wheel of Fortune set. Now, the court rejected a statutory claim under California law, which requires the actual use of the person's likeness, but allowed a common law claim, saying that the mere evocation of her identity is enough, right? So if people have an association with a particular person, there could be a right of publicity claim under California's common law. So if we get back to Bette Midler and the Ford advertisement with the sound-alike, the fact, first of all, that people would think of Bette Midler during it was enough for liability. And then secondly, there was some suggestion that people were actually confused and thought her voice was used, in which case there was a false endorsement in that case. Now, I don't approve of the Vanna White case, because I don't think she was used at all in there, and that's far too expansive a view of the right of publicity. But I also think that copyright preemption, which, as I said, I talk about in the book, has also become muddled, in part because of the shift we see in the Zucchini decision to treating the right of publicity as on par with copyright law, which has diluted the effectiveness of copyright preemption cases. And so you see a shift after Zucchini in which the copyright preemption defense is usually unsuccessful or frequently unsuccessful, whereas previously the copyright preemption defense was quite successful in these types of cases.
Have time for maybe one more quick question. And we will, of course, take more questions as we get back. So I'll grab one here. If we have time, we'll come up to the front.
So regarding the Hulk Hogan Gawker case, I would love to hear your thoughts about whose right to privacy was ultimately truly avenged in that case, given who actually financed that lawsuit.
I'm not sure that I want to comment on that in particular, but I think there were definitely some political motivations, obviously, in terms of the financing and an effort to shut down Gawker. And certainly we should be very concerned about big payouts for news coverage. So it's certainly concerning in that regard. I don't think that people should just be distributing sex tapes. So I have sort of mixed allegiance on that case. But I think Erin Andrews had a sort of uncontrovertible claim in her hotel invasion case.
My question is for both of you. Thank you both for being here. It's about the California law. I don't know if it's official now or still pending. That is sort of a gag order on the amount of money you make. And it's supposedly helping women. I don't know enough about it to say either way. It seems to me like it might be harming the very women it's hoping to help in equal protection and equal pay. But I want to know how it applies to both of your theories, whether it helps or harms some of the policy goals you're both advocating for example, transferability of talent and creative endeavors made by women or others representing women, and then also right to privacy and publicity.
I actually have an elaborate answer about this because I have a new paper about it. It's also, I mentioned the Rizzo versus Jovino case of the Ninth Circuit on bank decision that is really all about that prior history, salary history, and whether employers can rely on that to make an offer for a new salary for a new job. So I've heard that kind of being asked in those terms of a gag order, and there are lawsuits. It's actually not just California. Actually, it did pass. It is the law in California, but there are several other states that have that. There are dozens of states that have these kinds of reforms right now in bills. I actually think the research is there because of what I mentioned of a negotiation penalty, a negotiation bias, a negotiation deficit, and just a replication. So we know that the gender gap exists. We know that I think there's a very strong consensus among economists that a portion of the 80 cents to the dollar, it cannot be explained away by even if you take all possible observable factors like position and experience and time on the job and industry, occupational segregation, all of those factors that are more objective, a portion is the result of biases and pure discrimination. And if the pattern continues of asking, so what do you make? I'll just match that, or I'll give you $10,000 more, or a certain percentage, which is even worse because that compounds more than what you're making right now. Then again, we're compounding, we're exponentially increasing the gap, and we've seen really a stagnation in closing that gender gap. So I'm very supportive of all of these kinds of kind of what I call flipping the transparency or the information flows. It's not gag, but not giving that information that's contaminated to employers. But on the other hand, and that's a bigger thing that I've been advocating for, and there was just a new development this week, President Obama wanted an executive order of actually increasing transparency so everybody will see discrimination, not only in the job hopping, but in general. President Trump stayed that requirement and doesn't allow the EEOC to get that information. And a federal court this week said that's unconstitutional to not allow the EEOC to pursue what it's been, the powers that it's been granted to pursue.
So I think I might go a different direction in my answer, which is to highlight that, and one of the things I said towards the end of my talk is I think that we need to shift the right of publicity framework so it's less economic focused. So rather than boosting women's recoveries, we might want to reduce recoveries for people who are already making a lot of money by commercializing their personalities in their main career. Right now, the right of publicity is skewed so that people who are already winning in the financial lottery are getting more at the expense of all of us being able to talk about and comment on public figures and engage with them. Whereas people whose identities are being used without their permission for no good reason in ways that are truly quite harmful and disturbing to them are not recovering or not recovering very much. And so it's that imbalance that I want to shift.
Great. Thank you very much. Thank you very much again to Orly and Jennifer. We're going to take a brief break, and then I ask you to come back 10:15. Join us. We will welcome the rest of our experts, and we will kick off our roundtable and have plenty more time for questions. Thank you very much.
That is mine.
Hey, enjoyed that talk. Thanks for coming again. Sorry I can't stay for the rest, but really enjoyed it. Yeah, thanks.
I'm friends with Phil, but Phil Weiser.
Yeah, well, he's off to.
Yeah, I know. He's
Not bigger
Pete Green.
things,
Yeah.
but other things. Yeah.
Other things, yes.
Yeah, thanks.
Are you going to get rid of those slides?
All right, welcome back. Thank you all for joining us and for being here. Cara and I were just talking about, like, here we are with our tights exposed, and so we're ready. So we are going to engage in a roundtable discussion now for a little bit. I will keep an eye on the clock and open it up to questions after we've gotten through some of the topics that people are interested in just kind of presenting and throwing out there. So if you do have questions or you think you want to ask something, get that ready. And as soon as I come to a break, we'll turn it over to audience Q&A. I want to introduce briefly the two students who played a very large and substantive role in getting this together. I know that Dean and I mentioned them earlier, but they really can't be thanked enough. Chloe and Colleen are going to take the lead in moderating today's panel. So I want to introduce both of them, who are 2Ls here at the law school. I want to reiterate our thanks for Anna, for Susanna, who I don't see at the moment, but I'm sure she's around, Vanessa, to Kelly, and to all the people behind the scenes who are working and really making these Silicon Flatirons events work so seamlessly. So thank you again. I want to start off with just a brief question to get us rolling, and then, as I said, I'll let Colleen and Chloe really take it from there. One of the things that's personally interesting to me, related to a lot of the things that I work on, and I think has been hinted at a bit already in our discussions today, is at the intersection, actually, of intellectual property, gender, and antitrust. And that is the role that IP law can play when used anti-competitively, right? Particularly the concentration of power and the composition of leadership when we're talking about these culture-producing industries. So we get this, right up front with Orly's work that's talking about, like, what do the people, the executives in these companies look like, right? Who are designing the dolls, who are hiring the people who are marketing the dolls, who are deciding what sorts of toys and dolls to make, right? They actually play a significant role in dictating to children who are going to be playing with these toys what their toys are going to look like, and the way that they're going to be engaged in. So I want to open that up as a starting topic. Anyone?
I could.
Sure, please.
Okay. Now I see the problem. I'll just hold it, maybe. So my most recent work has been about the use of trademark rights, or the leveraging of trademark rights by corporations to gain exclusive rights to the use of public domain characters in the market for toys and dolls. In a specific example, think about a word mark for the name Rapunzel for dolls and toys, and the deleterious effect that can have on access to a variety of interpretations of that character, right? The maker of the doll or the toy tells us what that character looks like, defines what Rapunzel is going to be when they have exclusive rights to that name for a product like a doll or a toy that figures the character. And I think that concern is only compounded when we think about the ways in which large content providers are aggregating stores of characters with increasing sort of corporate consolidation, right? So.
And I should have mentioned this, but when you first speak, just maybe mention your name and who you are for the audience's benefit, so they know who we're talking to.
I'm Rebecca Curtin from Suffolk University Law School.
I'm Alex Roberts from the University of New Hampshire School of Law. I think another interesting aspect of that, related to what Rebecca mentioned, is not just about the corporations and who's making those decisions at the top, but about who knows how to use the intellectual property system. So I think on the copyright side, there's been some really interesting research, quantitative research around who's registering copyrights and who's suing and who the owners are, which have tended historically to be white men in positions of power. And then on the trademark and right of publicity side, I'm not sure about scholarly research, but there have been some great kind of essays and journalism around ownership of memes and who knows how to monetize something like having a pet who's famous on Instagram. or coming up with some great clip that goes viral. And of course, we can say, like, nobody should have any kind of control over that. But when it comes down to it, the people who are able to capitalize on that, register trademarks for things like Grumpy Cat, and then leverage them into licensing deals for millions of dollars and movies, and kind of take those to the bank, have tended to be privileged, well-educated white people, whereas others tell a really different story about things that they came up with that were the products of their labor that just kind of disappeared, and things that they were never able to profit off of. So whatever your stance is on whether people should be able to profit off of those at all, there are huge disparities in how that plays out.
To add what Alex is saying, I'm Cara Swanson. I teach at Northeastern University School of Law, and we're talking about who's in charge of these corporations and who understands intellectual property enough to be able to monetize it. There's also the question of who is recognized by intellectual property and what makes a trademark and a copyright. And I was really struck in rereading Orly's book about all the labor that disappears in the creation of the dolls. I was thinking of the seamstresses, and then there were women who were creating sculpting the dolls, a woman that was a logo designer, a woman that was a liaison, and all of these people are not recognized by what copyright calls an author, and they're not participating in the trademark work as well. So the way that we structure our doctrine also excludes and includes in ways that are very often gendered.
Something I was, to jump off of that, something I was really interested in your presentation, Jennifer, was the intersection of copyright and the right of publicity, especially as it plays out on social media with memes and whatnot. One of the Hadid sisters was just sued by someone for posting a picture of herself on her own Instagram because she didn't take the picture, but it's her own likeness. How do you think we can deal with that tension? Is there a way to deal with it?
Well, I have some suggestions in the book, of course, of how to deal with it. But that example you gave reminds me of an example I give in the book about something that happened with Brooke Shields. So I mentioned in my talk that transferability, if it's truly transferable, that means parents own and manage the property, the right of publicity of their children, and they can assign it forever to someone else. So Brooke Shields' mother, who was notoriously problematic, assigned not Brooke Shields a right in total, though she could have, but in a more limited way to a number of photographs, including photographs of Brooke Shields as a child in the nude. Brooke Shields tried to get that assignment of her right of publicity back, and the court denied it. And worse yet, she then wanted to be able, since she couldn't get that back or stop its circulation, to be able to use those images to tell a story in her autobiography about this difficult, painful experience with her mother. And the court said no, because the photographer held the copyright, and it wasn't a fair use to use that image in her autobiography. And I mean, right, so that's, to me, topsy-turvy and a very sort of emblematic and frightening example and so one of the things I talk about in the book is that copyright protects some of these zones of fair use, of which that I think certainly should have been one. But there's also a conflict that often arises between creators who hold copyrights and the performers that are captured. So whether it's in a photograph or often in moving images. So one of the examples we've been talking about, the Vanna White robot, but then of course there's the Cheers robots that some of you may be familiar with, in a case involving the long-running Cheers sitcom, in which Paramount Pictures licensed the use of the Cheers set and characters for use in airport bars. And they created these animatronic robots that were really based on the Norman Cliff characters. They were originally called that, then during litigation they were changed to Hank and Bob, but whatever, right? They're Cliff, Norman Cliff. And the actors who played Norman Cliff, John Rassenbarger and George Wendt, sued for the use of their likenesses in these robots. The trial court had held that they don't look anything like them. And in the book, I have a picture where you can see the robots and then see the actors and compare them, and they truly don't look anything like one another. And so this raises the question of whether performers can limit things that are usually within the rights of someone who holds a copyright to make derivative works, to license the characters, whether for dolls or in airport bars. And there are increasingly conflicts over this, and the right of publicity is often overtaking copyright privileges in this instance, and I think it needs to be rebalanced.
Could I actually interject a question now that transferability has come up again? Because I was struck in taking another look at your work for the conference that both of you are concerned about what we might think of as the dark side of the hand of transactions, transferability. And I feel pretty fully persuaded, actually, by the concerns that you raise. But there's just the smallest part of me, this former transactional lawyer, who thinks that these tools don't always cut toward the dark side, right? It's a lightsaber whose color is not always red. And is there a way, could you talk a little bit more about, or possibly there isn't a way, but if there is a way to sort of split that proverbial baby to preserve transferability in situations where it might actually protect the small inventor or help an individual preserve their dignity, right? Thinking maybe as an estate planning tool to the extent that rights of publicity are posthumous. What do you think about that issue?
I think it's really tough, actually. It's a tough question that you're posing because there's a history of the law of ideas as kind of developed outside of intellectual property and by state law. And the history is meant in some ways to protect that individual when they pitch something to a large studio, and how are they going to be protected? So there is that logic there. But then there's the reality of how it plays out in court. And so what I think about this is that the substantive law has to always, there's kind of these trade-offs and cost-benefits analysis in any kind of doctrinal decision that we make as policymakers or as jurors. We have to take the substantive law together with the process and the costs of enforcing those rights and litigating them. And so it's, I mean, in my book about Mattel versus MGA, there's that clear kind of disappearance of the small guy. So it's presented as a David versus Goliath story in the trial because Isaac Larian, the CEO of MGA, he presents himself as the other underdog, the David, but he's no David. He's a billionaire. The real David is Carter Bryant, who completely disappears. He's just a pawn used by everybody, and that's just really the reality where that stripping away of your human capital and your right to your persona and your control over your ideas and images and experience is, I think that it's quite uniform that it cuts that way of, and we see this, just to go back to that previous question about antitrust and market concentration. We're actually moving to a more concentrated market in every industry when we look at it than even compared to 10 years ago. So if you look at the entertainment industries, there's now the big six. It used to be like 60 studios. They've all consolidated, and I think there's just so much work. So you have to look at both the process and how it plays out in court, and also the realities of what the market looks like, and then what are you giving with substantive rights.
To chime in a little bit from the right publicity context, I think we tend to think of it as sort of an on-off. So it's it should be always transferable if there's some value, or never transferable. And I thought about some of the advantages people claim of transferability. And I think it's important to separate out the right for the living and then the postmortem right, because they're very different issues in how we should treat them. So, and I've had some very lengthy discussions with people from the Screen Actors Guild who really want it to be transferable, which seems crazy to me because it's many of their members who, when they're starting out, are going to wind up in perpetuity and gross transferring all the rights to their identity. So we have to dig a little deeper. So first of all, what is the advantage of having the transferable right? Well, there are a couple of advantages if you're Tom Cruise. Okay, right? So if you already have an established career and are not going to be forced into signing one of those predatory assignments of your rights, then there's advantage to transferring it away from yourself for a variety of reasons, from having someone else deal with enforcement and management, but largely to get rid of your tax liability, because then you can put it in a corporation and have all the income from that property flow in a tax-advantaged form through that. It also helps you with estate planning, because if it's a post-mortem right, then you can also have it passed down through the corporation and a trust rather than through your personal estate. So those are some of the reasons why very successful people find transferability beneficial. But I think the dark side will be for everyone else, all the people coming behind them and people like us who are just like, oh, we're on Facebook, terms of service, sure, right? Like, and then all of a sudden Facebook owns our name and identity. Meanwhile, we could have we could get some of the benefits that you might be thinking of in transferability simply by having limited licenses. They need to be limited, otherwise they become like assignments. But you could certainly, if you're captured in a photograph or a movie, assign that in that context forever, or license it in that context. Or you could have an exclusive contract for a certain number of years, maybe 7 years, like we do with employment contracts. The post-mortem rights are more complicated, and maybe I'll leave that discussion for later about what the value is in that.
I wanted to note that I recognize the currency that transferability can lend, right? If this is a form of capital that one can trade on. And I'm, as a copyright person, wondering what we think of the proposal to set up a termination similar to the way that we do with assignment of copyrights, right? So you can have a copyright, you can assign it, and then under the current copyright laws, it will terminate in the future, and then it reverts back to the person who assigned it. I wonder if we couldn't, if we're going to have transferability of rights of publicity, if we couldn't set up a comparable termination where it reverts back, and this could certainly help the Brooke Shields of the world, but might also help, the pre-Tom Cruise, who throws his stuff out there because he needs to pay rent, and then later says, actually, I think I'd like it back with the exact same policy justification for which we have it in copyright. Are there, and this is me thinking through this right now, so pros, cons, what do we think?
If it works like, I'm sorry, I'm Rick Stevens. I'm a non-lawyer here talking on behalf of my field, media studies, so we're interested in those kind of political economies. One downside is if it's like Disney, in theory, those expire. But unfortunately, the powerful often still, the continued extension of those periods where it doesn't actually enter Mickey Mouse will not enter the public domain, for example. It just seems like every time we get close, it gets extended. So how would you structure that in a way that actually benefits the people that you're trying to protect, instead of just creating just a lip service to the same kinds of powerful extensions?
Yeah, and you would worry about pre-waiver of the termination rights, which of course can happen. I'm not sure that adding termination is better as a policy matter than limiting transferability in the first place. Yeah. But I'll also throw out there, you are not the first person to suggest this. And so there have actually been discussions about it. And one of the things is that people may not realize this. Much of the right of publicity originally was sort of developed at common law, but largely now is a matter of statute from state to state. And so various interested parties, often when someone famous dies in a state, often an athlete or an actor, there will start being lobbying at the legislature for a post-mortem right of publicity, which will also include rights for the living. And so this will start out as a transferable right. The Screen Actors Guild, for example, has floated, after I think hearing some of my anxieties about transferability, well, what if we added a termination provision? But the movie studios, which then show up in the states where this is floated to make sure they get an exemption for motion pictures, doesn't like termination for obvious reasons, which is you have agreed to appear in the movie, and so if you can terminate your agreement to that and all the merchandising and derivative rights that flow from that, it's very concerning. So the motion picture industry is very opposed, is my understanding, to termination provisions for that reason. So just limiting transferability as a starting measure may be a better route.
I wanted to circle back to Gigi and think about her a little. So this is a woman who makes a living as a model and influencer. Am I on my mic? Yes. Okay, good. And so she's been sued. I think this is the second time she's been sued for posting a paparazzi photograph of herself. I think Khloe Kardashian or somebody else was recently sued for the same thing. And Gigi essentially posted to her social media, she said, look, I curated this outfit. I went out there and I struck a pose and I smiled for the paparazzi because I understand that to be my job. And this is a requirement of my job. And then I found this photo after the fact and I just wanted to share it with my followers. And the idea that I can't, that I'm now being sued, seems problematic. So thinking about the labor we were talking about earlier and thinking about the element of creativity that goes into copyright, and striking a balance with fair use, with rights of publicity, with ownership of content, I think we want to keep in mind what may be a gender imbalance, right? Because who's experiencing this? It's the Gigi Hadids, it's the Khloe Kardashians, however you feel about them. It's much more frequently women, and in fact, I think young women, than it is men. So when we talk about that balance, and I just shared that that story with my class. I'm teaching a class of undergrads in a course about pop culture and the law. And to a person, uniformly, they said, no, that's not right.
Oh, please, Anne.
So what Alex said just made me think, I'm sorry, Ann Bartow, I'm also at the University of New Hampshire School of Law. And when you think about the Kardashians generally, I know they're kind of a big deal. And they're built. Well, actually, if you take it back, just the idiocy of the intersection of copyright and right of publicity is if I was a sculptor and I made a beautiful sculpture in my front yard and someone took a picture of it, I might have a copyright case, right? Because they made an unauthorized reproduction of my sculpture. But if it's me standing on my lawn, I don't. It's kind of weird, isn't it? If it's a human body versus a sculpture of the body. But back to the Kardashians, and I always find myself in this curious place of defending them, but because they don't interest me, like as a personal thing, they just don't interest me. But I mean, some of the stuff that goes at them, it seems surreal to me because there's so much dumb stuff on TV. Why is the women's stuff dumber, like, you know, or more inane or more pointless? And particularly a friend of mine said, actually my son, it was someone else, I didn't add him on this, it was someone else, was making fun of me because I was cruising through the channels on one of them and I don't even remember which one. I got a little bit sucked in because I was trying to understand, it's interesting, how do really rich people live when all they have to do is, I don't know, look really good when they leave the house. I think now I'm making fun of them. But so anyway, so my son someone was making fun of me about this and I said, well, you know, what do you want to watch? He's like, let's watch soccer. Like, why is soccer more important than the Kardashians? Mom, or you. But you understand, like, because he likes soccer and he's interested. So soccer's more important. I mean, how many people think soccer's more important than the Kardashians? Oh, a lot of you, okay. You're in good company, but like, think about why. Because actually there's a fundamental question flowing beneath all this, which is like, what exactly is the gender that we're talking about? And how do we define the genders? Because Orly and I have talked about this a bazillion times. I mean, women are always, you usually don't even get to choose to be a woman. It's just kind of thrust on you. Not every. I mean, I know there are different situations for different people. But I mean, here you are, a second-class citizen for life, and after you get born, and then you can't do anything right because there's always a double bind. Like if you dress sexy, ooh, you're dressing sexy. That's not good. And if you dress kind of frumpy, oh, you're not even trying. You're not, portraying the best image for institutions. Like to this, to that. Like everything goes down. You really can't figure it out. And then when you look at intellectual property, it's really obvious how gendered the world is, basically. When you look at anything, what is it we usually put high value on? The works that are mostly, at least have historically been involved with men. The works of visual arts, the books, the plays, anything. There's a lot of gender analysis of Paul Heald. If you're interested in this stuff, there's a bunch of empirical gender stuff that's recently been done with intellectual property. The news for women's not good in terms of patents. The number of identifiable women who patent stuff is minuscule. And then there's some preliminary data on copyrights, which is the same thing. It doesn't mean that women aren't creating. It just means they're not registering their copyrights or litigating their copyrights or some combination of those two things. But if you look at things like knitting, crocheting, cooking, makeup, clothing, gardening, being a chef, a lot of those are sort of thought of as women's work until we commodify them as intellectual property, in which case the men tend to rise to the top. Like, right, women do a lot of cooking, but the top chefs are mostly men, right? There are a few exceptions to that, but not too many. And so kind of defining your terms and thinking back how deeply gender is embedded. And I've kind of reached a point in my thinking where I think I would be happy if I could just get people to see it, like before we even start to fix it. How many times do you have to say what your gender is for the most stupid occurrences? Anything, right? You want to log on to some site, you want to take out a credit card, forms, entry and re-entry. It's like I already have my gender in my passport, but then I have to like fill out forms coming and going just to reassure them, hasn't changed while I was gone, don't worry about it. It's like, well, why in the world do they care? It's just, but everything, check, tell us what your gender is. And then sometimes they'll add, prefer not to say. It's like, I guess that's the progressivism of our era. That's how we reach. Progress is slow.
Can I? Please. I really like the point that Anne just made. Oh, and I'm Casey Fiesler. I'm a recovering lawyer. I'm here in the Department of Information Science at CU. And you brought up what I thought we were seeing as a pattern, which is different kinds of creativity being valued differently. So things like seamstresses and the Kardashians and models as opposed to photographers. Another really good example of this is fan fiction, which has existed since the 50s and wrought with copyright issues the whole time, to the extent that there are chilling effects and it's kind of underground, in part because people are afraid of getting in trouble for copyright. And women have been making remix videos since the 80s with VCRs, and then suddenly YouTube comes on the scene, and it's like, oh, there's this amazing new art form. It's called remix videos, and men are making them. And then suddenly, like, it becomes more acceptable and less underground, in part because the people who are now engaging in this art form are less afraid of copyright because they're willing to fight DMCA notices and these kinds of things. And so it's interesting too how you see this shift where even if sometimes it can be the same type of creativity or activity, and then it's being dealt with differently in different kinds of communities.
Can I just interject, Casey? I think fan fiction has been in existence since the 1350s.
Oh yeah, Jane Austen,
invisible,
book clubs.
It's invisible in a pre-copyright era. We view it as manuscript variation in a manuscript culture. There are manuscripts of the Canterbury Tales in which readers have inserted their own tales. Right? This is a very old way of interacting with culture that is participating, creating, remixing, rehashing. Right? And I do worry a lot about this strange blip in history that's only been the last 200 years, generously, right? That has changed how we view that activity, or whether we view it at all.
So there's a sort of a feminist legal theory underpinning of this discussion of what Anne's brought out and Casey's brought out here, which is whenever we draw lines, and I think Jennifer said, we see it as an on-off thing, and I think both of the lines that Orly was talking about in terms of separating the brand and the ownership of the brand from the creator, and the line that Jennifer draws so well between the right of privacy from the right of publicity, that public-private line. Whenever we draw a line, feminist theory tells us, we're separating into categories, and we inevitably put one on top of another. And the public-private line historically has been women, private, home, men, public, commerce, valued, right of publicity valued with money, privacy not an economic harm. And when we have those, a hierarchy, inevitably, and this is what Anne was saying, women tend to lose. So when we think about what we're doing in the law, and when we're creating those lines in the context of a culture in which this is what happens with categorization, and we need to understand that as lawyers, and I think that's exactly what we're grappling with here. How do we think about, how can we make it not an either or so that we avoid that one's always going to be on top of the other?
I feel like I think a lot of this ties into the way that I think of many of the things that have been going on with social media of late, as we've said, regardless of what you think about the influencers on social media or the sort of the Kardashian-like culture. As Alex mentioned, like this is, at the moment, the realm of young women. This is one space in which young women dominate by a landslide, right? The influencers that we care about, on the whole, are pitching clothing, they're pitching makeup, they're pitching potentially, music and ill-fated music festivals and so forth, right? But this is the realm of them, and I feel like for that reason, because they don't get a lot of realms, right, where they're really taking dominance, it's important to stop and look and think about, okay, so how are our current or extant laws impacting them? How should they, like sort of more normatively? Are there things that we would like to put in place that, taking a sort of more objective approach, whether you want more of this or less of this, but that allow it to happen insofar as it's allowing an outlet for this particular demographic, I think is really interesting.
And to kind of jump off of that, Professor Garcia, something that Kara said about the difference between owner and creator that you see a lot of times in intellectual property law, I think a lot of that goes away with influencers, which is something I find really interesting. They're creating the content and they're owning it, hopefully, and it's their right of publicity. So I think that also kind of blurs the lines. And
Yeah, I don't know if people saw in the New York Times yesterday, there was an article about child influencers, right, 4-year-olds, and that made me worry because of this trend, right? I'm imagining, right, these kids are being sort of created into these economic beings, very public beings by their parents, who could then, of course, assign their right of publicity to someone else. Interestingly, DJ Khaled, first of all, like before his child was born, created a company to transfer the baby's right of publicity to. So DJ Khaled's son, actually his right of publicity is owned by a company now, not by the baby. And he had an Instagram account with hundreds of thousands of followers shortly after he was born. They intentionally misspelled the child's name so that they could then file for trademark registration for the child's name and then sue infringers who were creating merchandise using the name because, of course, it was misspelled. It was clearly a reference to DJ Khaled's son. And so this is happening, and I think it's and when I teach my right of publicity seminar, I have us work on a complaint involving, people probably don't know who this is, but there's this woman, Chachi Gonzalez, who is a teen MTV performer, and she had Chachi Mama pants. They were like baggy, so that the crotch was like right above the knees. And she started selling Chachi Mama pants, and her mother, who owned her while she was, essentially owned these rights while she was a teenager, transferred her right of publicity and the trademarks in her name and the Chachi Mama pants to a company. And then her daughter sued her, and they ultimately settled, so we didn't get to see the litigation play out. But these are the sorts of things that I think we'll see more of.
In my trademark class, I will often mention the example of, Jay-Z and Beyonce's first child, Blue Ivy, who we all know, when prior to, in similar fashion, and upon birth of that child, took out trademarks with the name Blue Ivy across everything, right? So clothing and toys and lunchboxes and magnets and whatever. You can look at the trademark applications, and I usually will present that to the students and say, so like, what's going on here? And a typical first reaction is like, a money grab for something of this poor infant. But then I show that more or less simultaneously with the birth of this infant, all of these clothing lines that came out with Blue Ivy labels that were not Beyonce or Jay-Z. They were just all these clothing designers who had come out with children's clothing in the Blue Ivy name and already had labels. So I just mentioned that to say, like, sometimes this is just preemptive. Like, if someone's going to be making money off of our child's name and likeness, I guess it should be us, or at least we're going to squat they wouldn't use that term, on these things, so that, by the time that the PTO realizes we're not actually using these things, they'll be less interesting, right? And so people may not want to, exploit the child's name and likeness. So that's something that also, as a result of our current laws, people of a certain level of celebrity have to deal with.
So there's definitely a huge rise in applications to register individuals' names as trademarks, right? I've written about it in the athletes context. And it has, for sure, for a lot of those people, a defensive aspect, including for NCAA athletes who are not permitted to use their name and benefit from it, but are kind of marking their spot and making sure that nobody else does that. But at the same time, whether that's about somebody with an intention or somebody who's already using their name as a trademark for all these different goods and services, or whether it's also about defensive tactical approach, it definitely reflects the rise in the human being as product, right? So, I mean, historically, what we're used to seeing for trademarks is company names and company brands that we understand as source indicators in connection with goods and services traditionally. And now we have to grapple with this huge number of people as trademarks for themselves. So if you pull up Kim Kardashian West and you look at some of her registrations, they say things like entertainment services for public appearances, which is a really consistent way to frame it, right? But in the end, what we're talking about is trademarks for people.
Well, I'll just add that you see these dynamics happening across many fields. So we've mentioned the right of publicity and trademark. I want to plug Anne's work. She has this analysis of the cheerleader Supreme Court case and the kind of blindness to the way that it's all about women's bodies and thinking about what is property versus what is part of our humanity and our images. But I also see it in the history of employment law. We say we moved from status to contract, and in some ways we've moved back to status just by virtue of being an employee, you are assigning so much to the corporations that employ you. And there's an interesting, when Jennifer was showing this slide of how there were more cases of the owners being studios and the actors are really women, actresses that were lending their talent to money making and commodification. There's also that history. There's an article by Leah van der Velde about how the famous case, if you take contracts, any law student who takes contracts has Lumley and the opera singer that was made to sing and kind of specific performance or negative specific performance. It really was that the defendants in these cases were 90% women who were singers, performers, and lent their actual talent, and then the studios were all men, wanting to profit from them. So I love how Anne framed it of let's just see those dynamics across all of these fields that we work in.
I wondered, would it be likely, or maybe this has already happened, that someone assigns someone else's right of publicity, and then the person whose right of publicity was assigned starts messing with the brand, like doing bad stuff? Like, can you sue them for doing something with your brand?
Yeah, I sort of hypothesize that could happen, and is another reason against transferability, if it's even possible. It just seems sort of absurd as a concept to be able to even separate out a person's name and likeness and voice from the actual person and have some third party own it. We haven't seen much litigation around this, and I think maybe that's just because it hasn't come to fruition yet and percolating up, or because often it's the people with the most valuable personalities about which we might see this litigation are ones who have a public megaphone, and it might not look good to have those sorts of public conflicts with them. But I do think only one case that turns out in favor of the publicity holder over the identity holder will work a sea change in these enforcements. This is actually an excellent venue for mentioning this. I was at a conference and someone came up to me and mentioned that a number of well-known actresses used to work in adult entertainment. And a standard part of the performers' contracts in adult entertainment is to sign your right of publicity in perpetuity to the producers. And I won't give more information about the person who approached me, but he just said that those companies know that they could potentially enforce that assignment on these now very successful mainstream actresses, and whether they should and how they could do that. Could they basically get payouts to not do so, or what would it look like if they do enforce them? How did you answer? I said that's one of the reasons why this right shouldn't be transferable. That's obviously very concerning. On the other hand, if we take the law at its face, then those are potentially enforceable transfers.
So I have a question. It's only vaguely related to this, though, so if someone else has, okay. So Jennifer used the term actress, which is, I think, now the common parlance. How many of you say actress and actor when you're talking about people who perform? And then how many of you just call them all actors? Okay, because I'm watching the regendering of, I'm not blaming you, it's the usage. But I'm watching the regendering of the language, because I felt like when in the 80s, we were getting to the point that it wasn't like, we don't have a farmer and a farm wife, you had a farmer and another farmer, we're kind of getting past it. And still, we don't call a female director directress or
right. Well, they used
produceress.
They used to call them directress.
Is that coming back for us?
But I just, to be clear, I use actor intentionally to mean both. And I use actress for very particular reasons. So I use actress because Nimmer, in his article, referred to actresses, and it was very gendered. A lot of the studio enforcement of their contracts was against actresses and typing of actresses. And so I use actress when I want to be clear that I'm talking about a female actor. And so in this instance, when I was approached about the question about former performers in pornography, it was only about actresses. The question was solely about women performers. It was not about male performers. Maybe the male performers don't cross over as much from porn to mainstream film.
Reputational stakes are different.
Yeah, or the reputational stakes are different, yeah.
Something I think that's been going on in, news to law students and to us in this room, maybe not news to other people, is the tattoos and video games and right of publicity and transferability and copyright. And I think that kind of encapsulates all of what we've been talking about right now. Could any of you speak to that and how tattoos, you can copyright them and someone can buy that, but you wear them on your body? And it's a really interesting situation, I think, if anyone has any thoughts.
There are actually a couple of really good articles written about. There's Yolanda, why am I spacing on? Yolanda King at Northern Illinois or Southern Illinois? And the book that Kate Darling and Aaron Perzanowski just put out has a chapter. So there's stuff out there if you're interested that you can read about. But I think it's really hard. And our friend Nimmer actually changed his mind in his treatise. He completely flipped. He argued initially that tattoos were copyrightable, and then he was hired during the Hangover dispute over the Mike Tyson thing. He actually edited his treatise to say that they shouldn't be copyrightable because it's tantamount to slavery. I thought, wow, that's interesting. View change and interesting timing.
Yeah, I think that it's a very interesting scenario. It's a work of art. It should be copyrightable. And then the question is, what's the scope of enforcement of that when it's put on another person's body? And
it becomes part of them.
Right, it becomes part of them. And so it seems like there's an implied license by putting it on the artwork on the human. And then, of course, it raises right of publicity issues because those particular tattoos, if you're well-known and your tattoo is well-known part of you, then it becomes an indicator of your identity. And so, right, and as the Tyson thing. So it's definitely these overlapping copyright, right of publicity issues, though where they're owned by two different
people.
Right. And because it's owned by two different people, I think it shares the concern raised with what would happen if your right of publicity was assigned and then you started acting out of character, right? So what would happen if, there was a copyright on the tattoo to your artist, let's say, and then you tattooed over it or you had it removed,
Got a really
right?
bad
We would
rash.
assume that we would not hold you down and not allow you to remove the tattoo from your body, right? I think that's the right result. But then what result? Like, have you infringed now, right? We don't have moral rights for destruction of art, but it's pretty borderline, right? So it raises, to me, and this is not even an academic argument, but when it gets to, when the question sounds so absurd, I have to assume that means that's not the result, right? But I've been wrong before.
But it is an academic question because it again comes back to what is copyright to begin with and what is infringement. And so actually, as we speak, there's another book event for a former PhD student of mine at Tel Aviv University who has a new book about copyright and derivatives. And it goes back to the fan work question. I mean, you could go back to history and understand copyright as just copying, just protecting against copying the exact same thing for the exact same purpose of, another person creating a tattoo. It doesn't, I think, have any real rationale or logic except for money making by those who are already in power to extend that beyond those narrow rights. And I think we have to argue against that and just like accepting the doctrine and what is misappropriation, what is infringement, what do you actually own in all of these pillars of intellectual property.
And what choices were made, right? I think that came up with like the Gigi Hadid thing too. Like she makes a really good point. Like the doctrine's more complicated than this, but is there co-authorship? Is there joint authorship with or without intent? Like what sort of creative choices were made and how much ownership, if any, does that give you in the resulting product?
And I think your point about holding people down really highlights the corporeality of what, when we're talking about tattoos, we're talking about people's skin and we're talking about human bodies. And there's a lot of discussion about like what does right of publicity do that trademark law doesn't already do, right? And there are plenty of stories of people, in particular famous chefs, designers like Kate Spade, other fashion designers, where a corporation takes the rights to that name and runs with it, and then the actual person who walks around in the world with that name is very limited in the ways in which they're allowed to use their own name. But at the end of the day, that's just a name, and that's not a body. And when we're talking about bodies in this really personal and intimate way, then I think we have to think about gender, right?
I think there was a lot of hypocrisy with some of the reaction to, also sexism, the reaction to the tattoos when they first started coming up. For example, Disney, and I can't pin this down, but apparently somebody from Disney, and they weren't speaking officially, was complaining because the women who tended to get Tinkerbell tattoos weren't up to his standards of attractiveness. So I know, it was really kind of gross, but it really got me thinking because there's another case, there's a Disney case, not about a tattoo, but about a woman who had a daycare center who hand-painted some Disney figures on the wall. And the argument that obviously impressed the judge, because he talks about it in the opinion, is, well, poor Disney, what if it turns out to be one of those horrible daycare centers that's abusing kids, and then they're doing their paperwork and it flashes across the wall. And that sounds reasonable until you think about the Disney stores. Because if she hadn't hand-painted it, she could have bought from the Disney store Mickey Mouse wallpaper, and it still would have been there when she had to do the perp walk. I mean, it's just like so artificial, that, it's just ridiculous. And the same, the tattoo, is it okay if I wear a Disney shirt, if you sold it to me? And what if I rob a bank in it? You're going to have to deal with that, right?
Yeah, at some point you have to deal with it. Yeah.
So to build on some of the things that we've been talking about with influencers, right of publicity, and the tension with copyright, I'm interested in hearing what some of the speakers on our panel think about Kim Kardashian suing Missguided, this clothing brand, for example, Colleen. But they've taken photos of her where she's wearing a designer's dress, and within a day or so they completely rip off the design and are selling it on their website, and that can kind of reflect poorly on Kim Kardashian when brands are thinking about dressing her, might make her think twice. And also, can they do that, and who do you think will prevail?
I read somewhere that she's working with them behind the scenes.
That's what we think.
So that was on Diet Prada, and I'm told that Diet Prada is just all about provoking. And so what they've done in that case is kind of change consumer perception, right? Because once they put that out there on social media, everyone's like, oh yeah, the reason that Misguided comes out with those designs so quickly is because Kim is working with them behind the scenes.
I'm not saying I believe it. I'm just saying I read it. Yes, it was on Diet Prada.
I think the complaint has solid footing. Sorry.
Oh, I was just going to say this raises important First Amendment issues, and I actually was an expert in a case involving Reese Witherspoon, and she sued a bunch of companies who posted on social media images of her, and sort of they sold, there were some companies selling fashion stuff. I was retained by a jewelry company. And so they would show pictures of what Reese and other celebrities were wearing on the runway and say, you know, red is in this season, you know, or whatever it is. And then, but the jewelry company would also say, look at Reese earrings. We sell earrings just like this if you'd like them. And so they're describing what she's actually wearing and then providing a similar product, which in that instance it was not infringing. So those are the sorts of things that I think are protected speech, even though they're selling because they're reporting. But there's some close issues there, which is slightly different than knockoff fashion wear, but raises some similar issues.
Right, I think the suit is really about what you're talking about, and I absolutely agree when it's those kind of one-offs that are very clearly, you know, we don't have a relationship with this famous person, but look, you can buy something similar to what they're wearing on our website. That's pretty clearly a fair use, but if you look at the Misguided situation, they're doing something a lot more egregious, which is kind of every tweet and every post is about Kim, and it's an image of Kim, you know, next to what they're selling, and there are other ways in which they kind of mark up and play with her images that really seem to suggest a relationship. So if you go to the website, you can click on Kim's fashions, and you can see like 15 pictures of her, and you can click on the images of her to find the specific outfit, which I think probably goes above and beyond. I do think Lanham Act false advertising covers a lot of that, but maybe not all of it, right? So I think there may be some space in which consumers aren't misled. They don't have an expectation that there's a relationship there. And yet, what you're really doing is capitalizing in a very clear, blatant way on somebody else's renown, on somebody else's fame and following to sell goods. So I think that could be an area where right of publicity comes in pretty handy.
It's the quintessential example, right? Like this look alike or sound alike. It's back to like the Bette Midler case where, like, yeah, Ford was very clearly capitalizing on picking someone who sounded a lot like, if not exactly like, Bette Midler, and Misguided is likewise using, in some cases, actual images of Kim, and in other cases, models who look so shockingly like her to sell the same thing.
So I want to turn the discussion just a little bit for a minute, thinking about Barbie in particular. I study cultural production, like how we get our norms out of media systems and out of commodities and things like that. What strikes me as interesting is how these different logics, both from commerce but also from law and then the culture end, kind of converge, where you have a situation where for decades there's been a feminist critique of Barbie that Mattel either ignored or didn't hear. That's an interesting kind of, now it seems like they discovered it in 2014 suddenly, which is interesting when they were in trouble. Yeah, exactly. And I'm interested in this idea that the competitor in question was offering a product that was kind of responding to those critiques, trying to change the norms of the production of femininity in plastic, to give those more expansive views. But the law is on the side of the person protecting their market. That's, and there's a reason why that logic works that way. So Mattel trying to protect their profit margins is kind of undermining our ability to have discussions and offer competing products that say not all women look the same. And I find that fascinating, just about how these logics kind of converge. I thought there might be some things we might want to tease out about how we can stop that from being the norm.
Yeah, I feel like that harkens back to the way we opened it, which is, my big concern and highlighted largely in Orly's work is about what happens when we have the laws inadvertently, perhaps, protecting one perspective, right? And in this case, in your example, Barbie's perspective of what femininity looks like. And then when there's a competitor presenting alternate versions of what femininity looks like, regardless of how we feel about either presentation, it can be silenced under the guise of, competition and copyright, IP laws, profit margins. And maybe that is really what they're focusing on, but the result is still silencing an entirely different view of the world. I don't know, sort of what the solution is. I'm sure Orly's given this a lot more thought, but I think it's a question that's very important and worth asking.
Yeah, so just to kind of challenge the way that you presented it,
Sure.
it's not that the law, as this kind of black letter or body of law, is on the side of Mattel and saying, nobody can
Sure.
create similar dolls. As I said, they keep losing, and eventually they lost on Bratz as well, and the two judges. I mean, they got the Wall Street Journal reviewed "You Don't Own Me," and it opens with the cost of litigation, which were just the money that went to attorneys, which were in the hundreds of millions of dollars, which is astounding. So it's that there's that chilling effect. So Bratz could have come earlier, but every time there was an attempt, there's the lawsuits and the cease and desist and really driving those brands out of the market. So to me, it really is that reform not just of the law, but of the legal process. And again, I see this, one of the things that we've been talking about is who owns your thoughts, but also your expressions, and the First Amendment, kind of bringing in the First Amendment on this. The other side of the coin is really that silencing through many different doctrines, and we see this today even with our president using NDAs to silence. And again, so much of it is not enforceable, but
Right.
If he's using it as this weapon, he's having an effect. And arbitration, mandatory arbitration clauses, and just getting more of education, not just ex ante, not just when a dispute arises, but beforehand, when people are actually just listening to a cease and desist letter that means nothing, that would not be enforced. Getting more penalties, criminal penalties, really, for these companies that are so consolidated and engage in unlawful collusions and behavior and unfair competition. I think, if you look at the ways that laws are enforced by our government, you immediately see the patterns of money and power, hand in hand.
You raised actually a great example, I think, when you're talking about your book cover, and that fear that resides with the publishers. I've published commenting on culture, and so I've seen that with, there's a long history of people writing about Disney who are not allowed to use Disney in the title of their book because the publisher is scared of that. So it's, the house that Mouse built or whatever, euphemism that comes from that, and it doesn't ever seem to be an enforceable threat, except the publisher knows our profit margins. It's going to happen. We can't afford a suit, and
they can't afford.
They buckle.
They can't afford to defend, and even these really small artists, and the cases that end up being winning cases, and I that was one of the puzzles that I tried to figure out in You Don't Own Me, like which are the cases that people are so bold to actually take on Mattel all the way to the end and not settle. So Isaac Larian says that he's just crazy, and he talks about the immense costs that his family and himself went through, just being every day there in the courtroom and having all these ups and downs and financial costs. So you need a very specific personality, but also a lot of these cases that actually do end up being our most important fair use cases in copyright and trademark, there are actually cases that the ACLU and other nonprofit organizations actually took on. So it wasn't the one artist that they would have not been able to continue with the case. So the Foresight case that I showed you, like Barbie in a blender and Barbie in meat grinding and all that, it was just the ACLU, and it was. I actually interviewed the attorney that represented the plaintiff in this case, or the defendant. She said that it was happening in Southern California, but no attorney was even willing to work with the ACLU on that case in Southern California because everybody was so afraid of Quinn Emanuel and those repeat players, and so they had to go up north to Oric and find somebody from the Bay Area to do it.
I think this brings up a really good point, which is the imbalance of power in sort of who feels that they can fight these kinds of things. I mean, if you even look at the copyright policies on YouTube, they make filing a counter notice for DMCA to sound like the most terrifying thing you can ever do. They're like, you can get in a lot of trouble if you're wrong. You should probably hire a copyright attorney before you decide, to deal with your non-commercial remix. And then it's so expensive to fight these things. I mean, even, sort of along the lines of fan fiction, the author of The Wind Done Gone, she won, but lost so much money in making this moral stance on this. Even I did like a feminist remix of Barbie a few years ago in response to what Rick was bringing up, and I got a ton of pushback by people telling me I was going to get sued. Oh my gosh, Barbie's trademarks, their copyrights, they're going to be so mad that you've turned Barbie into a feminist. And I wasn't even selling anything. And so it takes a lot of not only knowledge, but sometimes resources to do this. And like you say, most people don't understand fair use. And there's no one out there making it sound less scary for the most part, unless you're lucky enough to, get EFF to defend your dancing baby or whatever. That's the only time we see results like that.
Rick, I think you make such a great point, and I don't have an easy answer, but one thing I just wanted to highlight, when we're thinking about the intersections of pop culture and the ways in which it develops and the ways in which law constrains it and reacts to it, there's plenty of speech out there, right? There's plenty of response to images of femininity and things like that. But in the end, mainstreaming it tends to be a result of commercializing it, right? So if people are really going to hear a message, sometimes that means it has to be embodied in a product that's for sale, which is how it ends up running up against all of these different IP regimes. And maybe there's something tremendously problematic in that concept itself.
Yeah, if I had been able to sell that book instead of just putting it online, then more people probably would have seen it, right?
Good thing. So I'm going to open it up now to, we'll continue to chat here, but I'll step into the audience with my mic and take questions. The tradition in Silicon Flatirons is to start with a student. So if there is a student, please raise your hand and we'll start with you, and then it's open to the floor.
Hi, my name is Alan Magnuson. I'm at 2L here at Colorado Law. Fascinating throughout this entire panel were the ideas of the gendered effects, motivations, and abuses across sort of the entire IP universe. And I wanted to ask, if we're fixing that, how much work can be done in an IP law that is sort of inherently and constitutionally required to be disgendered? We have our authors, our inventors, our parties to the contracts, IP law that can't actually include genders, or can it? Or is the work to really be done just constant grinding or reforming of norms and commerce and culture?
That's a great question, and I'm interested to hear what the panel thinks. Certainly my thought in putting the programming together for today was that one important first step we can take is, just raising awareness about these impacts and these effects, which I'm happy to concede are coincidental and probably in many cases unintentional. And as I mentioned in the opening, this is not uncommon for the law to have sort of unforeseen side effects and things that are coming up as new platforms develop, right? Like, this platform didn't exist, so we certainly didn't know the law was going to end up doing this sort of thing. So I think awareness is one thing. Then what we do about it, it may or may not be the purview of intellectual property law to consciously change itself in order to facilitate some different result. But I think that being aware of and talking about the issues when new bills are presented or new amendments are presented might at least offer the opportunity to mitigate or to at least not aggravate current or extant inequalities that the law is perpetrating.
And educating juries in particular may be helpful in addressing at least some of the disparities and discrepancies that Jen pointed out.
I would say that it's a both and to your question. So there are all kinds of external barriers that the fact that many fewer women, for example, apply to get a patent is not something that's internal to the patent system. Right? There's a lot of external factors to think about that. But the patentable subject matters that keep a woman who has a lot of information about the cats that she's caring for and helps her develop a hypothesis about feline HIV and says that she's not an inventor, only the scientist who takes her data and works with it in the lab is an inventor. That's something internal to patent law, what we recognize as invention that we can change if we change patent law, and the same thing with the gardening, cooking, sewing. So those things we can do with statutory changes to bring more people into the constitutional definition of who's an author, who's an inventor, but then there are also external factors.
Any other questions? There's a few. Okay, there we go. That I saw lots of things.
Hi. So I was thinking about the case, I believe, from 2014 by the estate of Sherlock Holmes against an author who wanted to publish an anthology. And the other famous judge, who has not yet been revealed to be a perv, right, wrote that decision, Judge Posner, and said that Sherlock Holmes and Dr. Watson are not copyrighted. You can only keep a copyright on the later developed traits, and then awarded attorney's fees to the person defending an appeal because the amount in controversy was small and it basically was deemed to perform public service. So what does that case do to stem the perpetuity of copyright extension? And is awarding attorney's fees in cases where somebody has to defend an egregious claim a way to stem the chilling effect of specious claims?
I may have the wrong case, but the Sherlock Holmes case I'm thinking of, some of the stories had come into the public domain and some of them hadn't.
Yes, so Richard Posner held, well, the whole court
right.
That, the estate was arguing, yeah, but we changed, the author changed his characters later, so they have to stay in the copyright protection.
Of the books that are still in there.
Right,
right.
And the court said, no, only those later characteristics are copyrighted. The characters themselves, once the first story falls into the public.
Right. That's the important part, right? Because if you try to write, eighth Harry Potter, that case is giving you no help at all.
Yeah, I think awarding attorney's fees can be a valuable way if someone's defending sort of a noble use to incentivize those sorts of cases. But it's a double-edged sword, of course, because if you lose, you can have to pay debilitating attorney's fees on the other side. But one example that tracks that recently involving the right of publicity was the de Havilland litigation involving the miniseries Feud, in which Catherine Zeta-Jones played a character named Olivia de Havilland based on Olivia de Havilland, and Olivia de Havilland, who's 101, still alive, sued. And the trial court rejected a First Amendment defense to her false light claim and her right of publicity claim. The California Court of Appeal reversed and said the First Amendment absolutely protects this. This is a reference to a public figure in a work of biographical fiction, and it's strongly protected. And they awarded attorney's fees to Fox, and for the whole appeal, which were quite high. And so that was a clear signal that the court, people were surprised that they thought it would be each party to bear their own costs, especially since the trial court had gone into Haviland's favor. But the Court of Appeal wanted to send a message, don't sue over biographical films. And so they awarded attorney's fees, and that was very intentional. Oh, I think that it's huge. It's extremely well written and very clear case, and sends a very clear message that people shouldn't sue over these movies and books in which they're included, particularly public figures, but not only.
I want to build off of Alan's question about copyright potentially being inherently gendered, even unintentionally. And it struck me that some of the question there is about incentivizing female authorship, and to Kara's point about maybe there are some changes we can make to the structure and the words themselves in our regimes that incentivize female authorship. I want to ask about what that has the potential to do. My heart tells me that will have the potential to improve female representation, such that we won't have hypersexualized child's toys, for example. But I also wonder, what are the boundaries of that? How much will it really help? What are we relying too much on our women to transform our entire culture if we incentivize them to create content?
I'll just say that I mentioned before the psychology that went into the marketing that created the dominance of Barbie, and I think that it really is not just intellectual property. It's the massive ability to invest in the brand more generally. I'm a little bit more pessimistic about just fixing that one piece of the law and what kind of messages we send to the children and parents and what kinds of choices. But it definitely would mean more choices. But then there's these other fields that are at work in dissemination.
I worry, and particularly when Kara was speaking about sort of adding things to expand the patent regime or the copyright regime, or expanding the right of publicity, that will not be the way in which we want to improve things, that will worsen things in terms of an ownership culture and limiting speech and creative participation in ways that are far more concerning. Which is why I earlier was saying that the way to fix the right of publicity isn't to necessarily raise the recoveries for women, but to perhaps think in a more nuanced way about what sort of things we're allowing recovery for. And I think whenever we think about changing the system, thinking about gender is really important, and so in differential impact in different communities, not just gender, but people who are maybe less well educated or don't have the same economic resources. And so hopefully our discussion today helps highlight some of those things. And one example that's come to mind during this conversation is one argument that's been made among those who want to contract the scope of copyright is to bring back formalities and to have a requirement that you register your work in order to assert copyright protection, which of course, right, based particularly on what Alex was saying, would largely mean that the biggest copyright owners and content creators, big studios, record labels, they're all going to register. They're like on it. And most of the other people are not. The small creators and the less well-financed and maybe more women are the ones who won't get protection for their work. So I think when we think about reforms, like, oh, that sounds really attractive, that'll greatly reduce the amount of copyrighted works and copyright enforcement, but how is that going to play out?
just on the formalities and registration, I have to plug, and I want to bring back also seeing race in this mix. Our colleague KJ Green has done fantastic work about disenfranchising Black musicians over our history of music, and how the studios have been and the producers have been using either formalities or informalities. I think you're right that it's you can it's the repeat players who are going to learn how to game either system. But I agree that reducing those tools that can be weaponized is a good thing. So that's been my consistent argument in the human capital space has been, let's reduce the reach of these really draconian clauses that prevent voice and exit. Let's contract them and remember the lines that we've drawn with intellectual property.
I'd make just a quick suggestion going forward for those of you who are interested in this topic, is start when you're looking at intellectual property or things in the neighborhood like privacy, right of publicity, where situations where you see women overrepresented or women underrepresented, and then try to figure out what that might be. Like, why is it we know there are not enough women STEM students, so there are actually a lot of stuff going on, there's some money and some attention to try to get girls into STEM. On the other hand, music majors are overwhelmingly women, and guess what? No one cares. No one's like, where's the emergency? Where are the male musicians going to come from? They don't care. I mean, this is very odd. Why could that be? Is it the valuing of music if it's seen as women's work? And little natural experiments. Most of them are kind of depressing, but some of them once in a while.
Moreover, I would mention too, for better or for worse, as anyone who's either a copyright attorney or has taken copyright as a student would tell you, the Copyright Act is full of sections that are ambiguous and vague, and so there's a natural sort of, I think, built-in feedback loop wherein, let's just take fair use, for example, as long as we're talking about things that are ambiguous and vague. And so how we view and value things as a culture will feed back into then how those things are interpreted when they are either negotiating or litigating, right? So to some extent, then we might say, well, some of these things will not resolve, but maybe mitigate to some extent as our own views change and industry norms and customs and societal norms and customs change, because then we can say, well, all of a sudden we have this much broader view of co-authorship, and so now it looks like this because we say that it does.
Yeah, I was just thinking that this is a much broader problem than just copyright. I mean, same sort of thing for biased hiring algorithms. Like, why is Amazon's computer telling them that women are not as qualified job applicants? Well, because the data that you fed it were based on who you previously thought were qualified job applicants. And so there's this debate going on about how do we change perceptions when there's this feedback loop. And so as we keep having court decisions and cases that are making the same decisions because they're based on precedent, right? And so you have to start changing things slowly, which is really not a good answer. I mean, but it's a problem everywhere.
Also implied in your question, though, is a question about whether increased representation among creators as women alone, what effect that's going to have and whether that will be enough, right? So I think generally, yes, if we lower barriers of entrance to the market to creators of different perspectives and greater diversity, yes, that's a good thing. But I think it's also true or fair to say that women are not themselves immune to the systemic effects of gender bias, right? So if the question is that enough? Probably not. And we have a role as consumers of culture to find that non-sexualized toy and support it, or join a consumer advocacy group that's about, deconsumerizing childhood. Right? They're out there. There are ways to express what you want, and the market may move in that direction if we ask it to.
So I totally agree with that, and I have these optimistic stories because a lot of this is very problematic, but there has been a lot of change. one of the things that has been changing, again, thinking about the market more generally, not just as the content owners and the producers and the manufacturers, but also the retail, the toy stores and even the online sellers have really shifted just in the past few years from having boy toy, like blue and pink shelves, to having it more gender neutral. And a lot of this has been parents and advocacy groups and even kids. One day I was in just a candy store, and my then he was 7 years old daughter yells from the other side of the candy store in the mall, "Mom, come see these sexist Kinder eggs." And everybody was looking at this, and she's like, "It says Kinder chocolate eggs for boys and Kinder," they have it different in games, but that's the McDonald's Happy Meal has actually changed in reaction to girls writing letters about that, and Meghan Markle, I think, wrote those letters. So there is change. Progress is coming, but slowly.
So I feel like a lot of the things that have come up today come down to contracts and what's been negotiated. I mean, you can say whatever you want about IP law as a pretty much an IP lawyer, but I mean, I can tell you for sure the last employment contract I signed was pretty overreaching in terms of what it owned, which has left me with some concerns about things I published from here on out, but I'm not going to worry about it. They can't own the knowledge I had before I worked for them, I'm pretty sure on that. But anyway, I think that, there's some suggestions about and examples of legislation. For example, talking about pay, we have a lot of legislation now. You can't ask about your, former salary or your previous salary. And as someone who's in the job search right now, I have a great example. Let me tell you, recruiters have no problem working around that. I mean, got a really nice series of examples of a legal recruiter out lawyering me to try to get me to say something I didn't want to tell her. So that's great, or limitations on what you can transfer and blah, blah, blah. But I'd like to hear from maybe, most of you or all of you if you can, what practical advice can you give to people when they're in a position of negotiating, pick your, poison contract to not be inadvertently sort of bullied or overrun by whatever things you're, agreeing to in that moment of yay, I'm so excited about this, perhaps, or I'm desperate and need the job, or whatever, or need the contract to get my career started, and like the Ariana Grande example.
Well, I think, first of all, people have to, so their employment contracts are a little different, and ones that are negotiated from contracts of adhesion. And people may not realize this, but when you go to those jumping, I'm sure you have them here in Colorado, right, where you take your kids and they jump and you sign a waiver, they can kill your child and you can't sue them.
Right.
There's, right, yeah, so bouncy castle here, right, and sometimes those also have transfers, or at least assignments in a limited way of the rights to the images of your children to be used in all sorts of contexts, including advertising. I encourage people, first of all, to start reading things and start objecting and try to cross out and change things as much as possible and push back, on the camp form, on the school forms. And so at least locally, I have caused a little wave of parents, at least, who are reading, objecting, asking their schools to change their forms, particularly with regard to likeness releases for the children and the uses of children's images. So some of that can be done, and I tell my tort students that when they go see a doctor, they should try to cross out all the provisions that waive liability and point out that it's void as
They won't do it.
Right, they will, it depends how you do it. But yes, sometimes they won't accept it, but often it just, the person there doesn't care what you do and they just put it in a folder. So those are pushbacks. But when you're negotiating an employment contract, it's a little harder. And so you likely have a lot less leverage. And that leads you to rely on doctrines, contract doctrines, and others can speak more to these maybe than I can, but where you can void the contract for unconscionability or being against public policy. But at least in the right of publicity space, the conventional wisdom is that you cannot invalidate contracts on those grounds, that because it's transferable, if you know that you're transferring it, that's it. That's what they say. Right, yeah, so I mean, then you have to litigate that. Right, so then you'd have to litigate whether that is truly unconscionable, or I think it's a constitutional violation, but you have to litigate it.
I want to follow up on that point about the rights of children. I don't know if you heard about a case recently out of South Carolina involving a neo-Confederate group called the South Carolina Secessionist Party. And what they did is they had some kind of parade where they're all carrying their Confederate flags. And somebody there took a picture of a couple of little African-American kids holding a Confederate flag. And they put that on their website. And the mother was not amused. So she sued the South Carolina Secessionist Party for invading her children's right of publicity by using them essentially to say, hey, look, everybody loves the Confederate flag. And what happened was I think they brokered it looked like she was going to win because they had no rights to stand on. Their theory was, well, we took pictures, they were out in public. Yeah, but you don't use pictures of other people's kids on your website to promote your cause. And it's an interesting case. I recommend you check it out. The result of the settlement was kind of a Morris Dees type of thing where the Secessionist Party agreed to disband and is a part of settling the case. So I don't know what anybody thinks of that, but there are ways to use the rights of publicity in an offensive manner, not offensively, but in a way to, like Morris Dees would do, to stop people from doing things that are considered not appropriate.
Yeah, I think that's an underutilized part of the right of publicity and something that I advocate in the book we can do more of in those places, and maybe less for the people who are already making, hundreds of millions of dollars. And part of the reason we're not doing that is because of this real misunderstanding about the relationship between privacy and publicity laws.
It's a confusing area, and I think it's good to separate what's going on with the law and what's going on with social norms. Because I'm not aware of that particular case, but I'm on the other side of it too. Sometimes you just want to take pictures of the neighborhood, or you see something striking, you want to take a picture, maybe you put it on your blog, maybe you put it on your website. I know some of our own institutions make our students sign agreements that we can put pictures of them in our catalogs, or our websites, our brochures, and I know sometimes that's used in ways I'm not always comfortable with, because one of the things, University of New Hampshire is like the second whitest state in the country, and our student body is very white, and I feel like there's a couple of really attractive people of color that are like half the catalog, and I'm glad they're in there. No, I'm glad they're in there, but it's just like they're trying to communicate, other people be welcome here, so it's like the goal is good, but then the mechanism's a little uncomfortable. And then Facebook and parents from athletic events, constant tension of whether picture, if your kid's hitting the home run, but the catcher's mother doesn't want his picture in,
But I think there's a big difference between documenting, like, here I was and here were these kids, or telling a news story about that occurrence and then using the same engine to promote your organization or to sell a product or putting it on a mug. And all of those are different, and how we analyze them as to the speech rights or the speech of the individual person posting it versus the rights of the identity holder are going to match up differently in a very fact-specific way.
That's similar to fair use and
yeah.
I think there's some slippery issues there, edges of that approach. They're like Pinterest. You're putting it up there for other people to use it, but it's sort of a home style. You know what I mean? It sounds like a great line, but it's just, in practice, I think it can be a little trickier. You don't know if something's going viral. If you allow people to share stuff off your Facebook, it could go. You just don't know, and you're never going to get it back. Control.
Hi, my name is Ray. I'm a 3L at Loyola Chicago. I just have a quick question regarding the celebrity children's right to their publicity and protecting that, considering society's obsession with certain celebrities and everything that goes on within their lives. How can those celebrities best protect their children's right to their own name and their own
personal brands, essentially, when people are going to be trying to exploit that celebrity once that child is born and into the public stratosphere.
Well, I think Christina is right that some of the registration of these children's names, and I think Alex said too, as marks is defensive, is to try to assert their rights and stop people from selling products and services under their names. I think the right of publicity can be exercised and employed to protect those children, as well as straightforward privacy-based claims for some intrusion upon the family's seclusion claims as well, without needing to incorporate and transfer those rights to a third-party corporation. So I don't think we need to go that far. I think there are lots of tools that can be enforced. And then there's a little bit of what Anne was just saying, which is there they are, they're out in the world, and there are public figures, and they have kids, and we're going to talk about them. And in fact, that helps them in many ways to curate their brand, as parents, and to develop their marketability. And I think what we see is, there's some effort to do this, to register and transfer their rights of publicity and manage their Instagram following and Twitter following of babies that can't speak and have made no choice about whether to commercialize themselves or not. That I think goes far beyond just being defensive, and I think should make us uncomfortable in the same way that at least some states, like California, has passed laws to protect child actors so that their parents can't take all of their earnings and leave them destitute when they turn 18, which has happened, and we don't have any laws about either celebrity children or just identity holders in general and from their parents exploiting them in that way. I know New York also protects child models by having some provisions that their contracts are reviewed, that their parents can't sign a contract without it being reviewed by court.
The ethical normative issues in this go beyond celebrity, are not limited to celebrities either, because there's a lot of people are starting to think about this issue of people who are creating a blog to talk about parenting when the kid has just been born, and then suddenly when they're 15 and they're there are pictures of me smearing whatever it when you're do they have any recourse at that point, because they're not necessarily being caught up in publicity laws, and so it goes back to our more about vague and ambiguous around rights to privacy.
We were just talking about this at a dinner last night about the opportunities, for better or for worse, that social media presents for parents of minor children, and we didn't have this obviously when I was little, but I have 2 small children now. I could start Facebook pages or Instagram feeds or Twitter accounts, and I could, post all sorts of embarrassing photos and anecdotes. And, when they come of age, do they find that charming and cute? Do they want it taken down? Is it mine? Is it theirs? Right? And those are questions that are not easily answered by our current laws. And I think in terms of protection, as Jennifer said, there's a combination of things. I think trademark is very limited because of its use requirement and that sort of thing. So maybe we're looking more towards privacy laws and to some extent rights of publicity. I don't think the full magnitude of what that could look like has been tested yet, but I suspect that's where it lies.
Your question was super interesting, and I thought it was going to go in a different direction. I thought you were going to ask about protecting children's privacy, the children who are the children of celebrities or the children of politicians or people like that, and instead you asked about their own personal brands and cultivating their personal brands. But I think paradoxically the answer may be not what we're talking about here, but the opposite, right? It might be that those celebrities who make the choice to not announce a birth, not tell a name to the world, not share photos, those children are then best positioned to be in control of their own identities as they grow, right? And decide if they want to be a Jaden Smith and do all kinds of projects, or if they want to be kind of an anonymous, normal person for a while. And I think, as we're probably heading toward the conclusion of this, and we've focused on gender, and we've also tried to be intersectional and think about how these laws affect members of marginalized groups and races and identities, we do seem to keep coming back to children as being particularly in need of attention and protection. And this seems to be something that we're grappling with on a really large scale right now.
But I'll just say that it's also very gendered. So I've heard a lot of this, there's this new opportunity through digital media and Instagram accounts and being a social influencer to build a career sort of out of nothing. And I really have this cringing moment where every year I have students in my seminar, in my IP seminar, basically trying to figure out what they're going to write about. And it's always women who want to write, I want to write about social influencers because it's so attractive. But if you actually look at the numbers, how many actually profit and versus the risks, the costs and the benefits there, when you look at the number of firing of employees that got into trouble because they posted something on Facebook, it is very sexualized, very gendered. It's the women that get in trouble with, wearing something too explicit or, seeming inappropriate much more frequently than the men. And it's young women, so it's children turning into their adulthood and having to understand that there's so many risks in managing their image and identity online, and that there are going to be real career consequences to it.
And the flip side of what you mentioned earlier about being in charge and ownership and creativity is that corporations are viewing influencers as super cheap labor, right? You don't have to have the photographer and the director for the shoot. All you have to do is pay this one person and they'll take care of all of it for you. So there's an extent to which that market is particularly exploitive of young women as well.
Yeah, I just want to say thank you to Orly and Alex for bringing up the issue of race. And I think every time the word gender has come out of our mouths, we could have also put the word race there, and I think we could also put the word class there, right? That it's, we were asked, of course, to specifically focus on gender, but these things are very much interwoven.
Great. Well, I want to take the opportunity again to thank all of our panelists, to thank our two presenters, and to thank you all for joining us today, and to invite you to continue the conversation. Next door, we're going to have lunch, and we're also going to have a book signing. So if you have brought your own copies of either book, Jennifer and Orly will be happy to sign. We will also have for sale copies of the books if you are interested in taking one home with you. Thank you again, and thank you guys for being here today.
Thank you.